And the following order was passed. Thereafter,
Item 12.
on 9/2/2026, item 12 लिखिए ना, on 9/2/2026, the matter was again adjourned at the instance of the petitioner. Apparently, despite the pendency of the matter and specific issue raised before this court regarding securing of the amount for seeking revision before this court, the matter is adjourned more than 1 month. So this is more than 1 month by the petitioner. Today, the matter is again listed at serial number 1. Adjournment is sought by Bablu
Barik.
Mr. Bablu Barik on behalf of S.K. Bhanjadev. The last chance, the matter shall be listed. Last chance to the petitioner, the matter shall be listed in the week commencing. Yes, the week commencing 16/3/20 service. It shall retain its position. Yes.
Item 12. Item 7, my lord.
One that
Item 7, my lord.
Yes, sir. 7.
I pray for 1 week adjournment. That I have obtained instruction regarding the secure of that amount, my lord.
The matter was adjourned on behalf of the petitioner on 5/2/2026. For seeking instructions, for providing instructions to the learned counsel regarding securing the money decree as indicated in the said order dated 5/2/2026. এটা কেতে 7 রাখছন্তি না আপনার নাম আছে স্যার Prakash Panda, Mr. Abhilash Misra. Today, the matter being in the list is mentioned at the beginning of the proceeding and adjournment is sought for. Today, matter being in the list, and first order review. That's mentioned as adjournment functions. To grant further opportunity to the petitioner, the matter listed in the week commencing. How much time is Mr.
23rd week.
In the week commencing 30 रे बाद अधिक गोटे मैटर हो गलानी 78 पहुंच गलानी 30 3/2024 30/3/2024 that petition for seeking repeated adjournments from this court during pendency of the revision application shall provide instruction. Yes, next please.
Page 2 to 20.
Yes, sir. 12.
Item 12. Therefore, 2 week adjournment.
The matter is listed for fresh admission. The matter being in the list is mentioned by item 12. Matter being in the list is mentioned by the learned counsel for the petitioner. Sir?
J. Sahoo.
Mr. J. Sahoo. Earlier, the matter was heard at on 18/2/2026 and was adjourned at the instance of the petitioner. To grant further opportunity, list in the week commencing.
30th.
Again?
30th of March.
Sorry, 28th. 28th तो नहीं अप्रैल ला पड़ पड़े पड़ा अप्रैल ला देखो देखी मार्च 16 23 30 the week commencing 30th March 2023 26 I'm sorry 26. Yes, next please.
Page 3 21 to 27.
My lord, time on BC, my lords.
Page 4
My lord, time on BC.
22,
Item 22.
23.
Record pause. One second. See, as you already. Conclusion, sir.
Item 22, my lords. Kindly
22 yes. कौन चाहूँ सर
kindly be adjourned for last 23rd of March, my lords.
এটা অর্ডার্স ম্যাটার না, এটা অর্ডার্স ପାଇଁ লিস্ট ହେଇଛି, some judicial order has to be passed. ଆପଣ କାହିଁକି adjournment ଚାହୁଁଛନ୍ତି କହିବେ ନା ମତେ ଡାଇରେକ୍ସନ ଦେବେ ମୁଁ adjourn କରିବି?
ନାଇଁ my lords, ଆଜି ଗୋଟେ ବାର ଅଛି ଘରେ ତ ମୁଁ ସେଥିପାଇଁ ଯାଇପାରୁନି.
Personal difficulty.
Yes, my lords.
ସେଇଟା କହିବେ that I have personal, though it is a orders matter, I have personal difficulty.
Yes, my
Develop
lords.
smooth habits. You don't have to be prompted. Mr. Panda,
Yes, my lords.
ऐसा नोट कर देते
23rd of March, my lords.
6-3 से orders नहीं की 6-4 से कहो चुके कोर्ट मास्टर.
Much obliged, my lords.
Yes, that's all. You are Mr. Panda, Ankan Panda.
Ankan Panda, my lords.
Right. Yes, next.
Item 28.
Yes, please. 20. 28, अच्छा. 28 next page. 27 up to 27 किया चंदी? Yes. Page 4.
28 to 33.
Item number 30, my lord.
अरे गड वेटेड कहले आपण प्रेजेंट से कहउचंती टिके बी पेशेंट आपण डिसोरिएंटेड ले केमते हो. Yes, Mr. Das.
This year, several adjournment given to my friend, government advocate, to file a counter. The distressed person, no counter filed yet. This is
से
different cases.
एबे आपण माने एब्जॉर्नमेंट माने सब्जेक्ट करछन.
नहीं, मुझे तो
ଆପଣ କଣ कृषि object କଲେ ନା?
खाली
सुनें का? 28 car, Mr. Sahoo. Mr. Sahoo, Mr. Das is making a mention. I hope you have heard him. He's saying that repeated adjournments have been made.
Yes. But here already the parawise comment has been received, my lord, recently, my lord, and we are preparing the draft counter. Lord, kindly grant.
He told me that since yesterday there was a lot of opposition, so I will oppose the adjournment. What is your answer?
I am not there. Yes, I have received already the reply.
He is not this photograph. He's saying he's not there. Mohanty? He's there, na? Okay. He goes, I am not there.
No, 20.
No, I have not that issue, your lordship.
His photograph.
In this case,
So,
my
like
lord,
that, Mr. Mohanty, your namesake, Mr. PK, is also saying that it is your video only. Yes. Quebec.
three weeks time given to sir already received the parawise. 3 weeks time.
But 3 weeks no to, but please complete the pleading. Serve it.
Yes, my lord, I will do that, my lord.
अपन जो मैंने बारंबार in fact
distressed. Anyway, may I suggest one thing? Chief State Pouchon,
से सॉल्व कर रहे
rejoinder with it.
correct that order I will pass. So अपन के Mr. Sahoo, you will be filing counter within आज 6 तारीख आपनकर देई परिबे 25 सुधा
25. Yes, my lord. Yes.
21 27 27 शनिवार कोन छुट्टी दिन काम न करू 26 तारिख सुधा आपण दियंतु
Again, sir.
कॉपी सर्व करिवे
Again. Yes, my lord.
in the week commencing 13 कहउछंती the petitioner shall have liberty to
Put rejoinder in the
rejoin.
middle.
Okay. सेटा एबे लिखियो पढिला
Yeah. Obliged.
mention. Yes, next please. 28 ପରେ 29 ରୁ 33
Lord, item number 30.
30 yes please.
Might be taken after 2 weeks.
Others should inform करंतु actually after notice matter रे after recess they come and they see that the matter is adjourned, they wait. Please inform this practice you have to develop. You have to involve yourself in the matter. It is not job of the court to find out and inform. आपण कहाँ पे appear करछंती?
Petitioner.
Petitioner. Your name sir?
SS Spikra on behalf of
SS Spikra. On behalf of AK Naik.
Yes, madam.
But please inform who is the other side. No one is upon that exercise at least that is after notice. ठीक अच्छे डेट नहीं था तो देखिए ऐसे कौन कहउचंती. But please try to there is a method also. Suppose you do not know his phone number, you come take the brief from the court master, get his phone number, you can call him. You see, suppose we used to take an adjournment and we have not informed the other side. Our senior used to pounce upon us. That date करंतु
We consent
13 week रे आसो after notice matter. On behalf of Arun Kumar Naik, SS Spikra. ठीक अछि. 31 to 33. 34 to 40.
Item 39.
Yes, please.
I am from the opposite party, therefore reduce time to file count.
amnesty ହବନି କିଛି ସ୍କିମ୍ ଆସିନାହାନ୍ତି ଆପଣ ସବୁଥିରେ amnesty ଆଣିକି ଏଟା କ୍ଲୋଜ କରନ୍ତୁ. First you test it in the anvil of amnesty scheme. Because if you stifle these organizations who are employing people, it is labor intensive organizations. So by freezing the account, garnish order, everything gets stalled. So whatever way you can negotiate, केबे आसीबो 39 simple adjournment आपण कर देबे. I am not passing any order, Mr. Ray, but you have to take it seriously. You have a meeting with your senior officers who can take decisions.
Yes.
That why these matters are in garnishee proceedings, then matters are kept pending. Basically, not I mean much to adjudicate. It's only a count. But please inform the other side. It is a 35. They'll be waiting till 4:30. At times they have to wait. Please appreciate that. 35 date kale.
We council
Fair cherry विक्रेसी. The posting है. कौन लेके देते? Yes. Call the list.
item 2,
One अपन order में खींचो. है ना? The matter being in the list will mention should actually add to Srinivas Satpathy for the petitioner.
My lord, on the last occasion, state was directed to
So
take.
DN Venka for the opposite party. AG. DN Venka.
today,
Instruction asichi.
yes, sir.
Okay.
Okay, your lordship, I am just passing.
No. Since this is a content matter, you file affidavit. Serve it on him.
No, instruction that today the screening committee is sitting to decide the matter.
So it's a good thing. So that's a positive development. So I'm simply adjourning it. He'll be happy. What is
Yeah.
there? Mr. D.N. Lenka for the AG extending. The Lord Counsel for the petitioner refers to the earlier order dated 9/2/2026 and submits that instructions is to be provided by the opposite party regarding compliance of the order. Stop. In response, the Lord AG submits that he has received written instructions.
Yes.
That should I write screening committee?
Yes.
The screening committee,
To decide the distress condition, sitting to
screening committee is sitting for consideration of the matter of the petitioner in terms of the order dated 15/2/2021, disposing of WPC number 5314 of 2021. Stop. Para, accordingly, the matter is adjourned to be listed in the week commencing. Chauchari, Mr.
Yes.
Chauchari, yes.
Item 3,
May I please, your lordship?
Yes. To Santanu Kumar Sodangi, senior advocate, along with Mr. Gyanaranjan Naik.
Yeah.
So Gyanaranjan Naik for the petitioner.
My lord, this,
Yes, please.
I seek to challenge the initiation of the certificate proceeding in the present matter which has been initiated pursuant to the order of the, my lord, Green Tribunal.
So Green Tribunal order has been challenged.
No, it has not been challenged separately.
The Green Tribunal order,
Is there
page.
page and next page 43. It is regarding lifting of sands, my lord.
You are party. You are a party in that proceeding. DD Builders Act.
I am a party.
OP number 10.
I am 10.
Okay. Yes. What is the direction to you?
There is no direction to me. There is now the demand is about 9
So
lakhs.
kindly go place that order, the Green Tribunal operative portion.
Oh, I will take your lordship here and there. I will show your lordship so that it will be clear, my lord, from few paragraphs.
Yes, I'm at Green Tribunal order. Starts at.
Yes, my lord. Your lordship, I look at page 47.
Yes, I'm at page 47.
During the inspection, the committee members observed the following points. On the day of inspection, there was no mining activities at the LS site. Any type of mining machinery like highwa, such and such dumpers, tractors, etc. were also not found in and around the LS mining site. The allegation against me, my lord,
Kindly refer to the mining site above that, where the mining site has been referred.
mining site is, my lord, Siripur village.
Page 47, top line.
Joint inspection site of Siripur sand quarry.
Vibor Bahuda, plot number so and so.
So and so. Where the
Tahsil Chikit.
Counsel Secretary was held on 30/11/2023 to verify allegations made by the application during inspection. The following members.
So this is owned by you. You are the.
No. I am a transporter. I have allegation is that I have transported sand
From Siripur.
from that area, from that. Then my lord, page 48, paragraph K.
No, kindly place that report.
Report as a whole, my lord.
No. That finding portion, following points. What is the finding before the learned?
On the day of inspection, the revenue inspector of RI Circle Nuapada was present, identified Siripur mine such and such. I am skipping these, your lordship, may not be required.
No, C is important for you.
During visit, the committee members also
Sorry,
interacted.
B rather.
D.
B, C ru padho.
Sir, the revenue inspector of RI Circle Nuapada was present and identified the Siripur sand quarry, which is located over plot number such and such, area such and such.
Particular plot at the top of page.
Yes, my lord.
Yes.
The area,
during-
during visit, the committee members also interacted with the local village of Siripur, informed and then there was no mining activity in the LS Siripur quarry since about last 1 year. The water flow of the river Bahuda at Siripur region was found in lean condition. Sand was found to be extracted from Siripur sand quarry, considered to be illegal mining, and no lease agreement has been executed till now. At the site, Tahsildar Chikiti has informed that regular enforcement activities being conducted in that area to prohibit the illegal sand mining and its transportation. Under the enforcement activity, they have collected penalty from the vehicles engaged in illegal sand transportation. I have also paid, my lord. The committee also observed that another sand quarry, namely Sundar
Vira Chaitanyapur.
and such and such. Amrat allegation
Vira Chaitanyapur river sand bed.
such and such. Suna Chaitanyapur, Sri Santosh Kumar Behra Lessee is located downstream of the Siripur sand quarry. The lessee has obtained necessary statutory clearance, mining plan such and such for operation of this source.
You are extracting sand. You are only a transporter
I am a transporter
from Behra,
from this Siripur.
Siripur. But whether from Behra or the 130 to 130 by 830 plot.
From these plots, my lord, this Chikit first plot, Siripur
Okay.
plot. Then I take your lordship to paragraph K of that report, 48. The villagers inform the committee members that DD Builders, I am DD Builders, and ARSS companies along with Sri Santosh Kumar Behra, lessee of Sundar Bitrapur river bed, was involved in illegal mining from both Siripur Land Quarry and Surbhadra Birchapur river sand bed. This is the allegation. Now, my lord, may kindly look at which was the committee.
But I cannot go to the committee. The problem is that you are saying that you have not challenged the order of the tribunal.
Nice, sir. Challenge the
That's
question.
the problem.
Sir, I am questioning the authority of
Correct. But
authority
the problem is
of
that
Tahsildar or the
could be, but that order, the Tahsildar order has to be challenged. Committee order has to be, NGT order has to be challenged. Any finding against you, unless that is challenged or at least questioned to a certain extent. How do you question? It is up to the choice of course, for the.
that is something your lordship will quite agree with me.
No, but
With
the
Mr. Jano came to me,
difficulty is that I cannot delve into those issues.
Your lordship may submit, my lord.
Please.
Could it be possible on your part to look at my submission that it could not be initiated under OPDR Act? It should have gone to the Mining Act, my lord, the very initiation. And once you have
How
come,
does it make a difference?
it makes a difference.
There's a demand on you. Suppose you are saying that this cannot be a public demand.
No, it will be a public demand.
Then
Ultimately, it will be public demand.
it doesn't make a difference.
It makes a difference also. Who
Because unless you challenge the finding of illegal query and your liability to pay the government is concerned, imposed by the NGT, maybe illegally by the wrongly by the
Imposed
Tahsildar.
anything, my lord.
No. Direction.
Your lordship, I looked at the direction.
Direction.
Your lordship 65. My lord finds that.
K, and actually the problem is that I cannot overcome the facts of these findings of NGT, which is not on the
Exact
channel.
commit, my lord. First, your lordship, I will show page 65, then I will answer lordship's query.
No, it's not a question of answering.
My lord?
Facts. The question is that the point is you are very clear in your submission that you have not challenged any finding, NGT, Tahsildar, nothing. You are coming, and that plea, maybe they will, there is not a public demand, you can raise there, that's different. But I cannot adjudicate, I cannot become the ADM or the collector.
No, even collector cannot decide this.
Whatever, because if you are raising an issue of jurisdiction, a read court, exercising 226 mandamus cannot decide it. You have to ask the person, he may decide it correctly in favor of you. They will be aggrieved, they will be challenging it. That's a different thing.
Your lordship may give a pause there. Why I am saying? Your lordship may look to page 65. Who was supposed to recover the amount?
So that is besides the issue. Your problem is that you have not challenged. That's the problem.
Simply not go back to that. That is right. Page 65, clause 3. The director of, my lord finds that.
Unless you say that you are not liable to pay anything.
I am not like
A denial of that, because that says, you see, the language used in OPDR Act is very clear. That language they have used. Please appreciate what you are saying is there. I'll not, you just go through your chain of thoughts. You will examine that plea is also actually available. Now you are saying lack of jurisdiction by the demanding authority, not with the OPDR authority.
yes.
Lack of jurisdiction by the demanding authority. Now the demanding authority invoking OPDR authority to collect it. There you are,
Yes, I am on that.
that you have to reach before there, no, not before this court.
I do exactly do that, my lord, but your lordship may bear with me.
65 you are saying.
Clause 3. The director of mines and geology department is directed to recover the penalty amount imposed on the miners
I'm
responsible.
not reading actually the entire thing. Selective reading creates the problem.
This is the direction.
One is also a direction.
The respondent to ensure that the remediation measures of the said Sairat
And site are implemented. That is precisely within the jurisdiction of the Tahsildar. And somehow they thought it to make it so wide, remediation measures. And then kindly read 2.
State Environment Impact Assessment Authority, Odisha shall ensure strict compliance of the EC conditions.
So it is now, I don't know, it could be AC condition, I don't know.
Sir.
Sir, AC condition has been asked to you, you have been asked to comply AC and pay fine.
No. I have already.
So one takes care of your case. Then
The director of mines and geology department is directed to recover the penalty amount imposed on the miners responsible for the illegal mining. They are where I am. Here they don't say that.
one is your actually selection. You know what?
Then it comes back to another thing that I have not questioned that.
Obviously. Even mining, you see, the problem is that this court cannot say that you decide, but this court can definitely interfere if you decide. And they can also question. I mean, they may be agreed.
Yes, sir, that's right.
And OPDR, yes, Mr. Lenka, have you please completed your submission, Mr. Lenka, to respond? Or
No, if your lordship is indicating that, means
yeah, I have to.
Your lordship, is my lord sitting tomorrow?
Yes, Saturday.
I will come back to your lordship tomorrow. I will take a
Just
specific.
let us hear, Mr. Lenka. We have spent a lot of time in hearing. Yes, Mr. Lenka, what is your primary response?
I have to first to take instruction in such matter.
No, regarding this preliminary issues, of course, factually I am not asking you. Why should you? I mean, why should you skip out your need to say anything? But the general principle, whatever has been discussed with the senior.
It is a proceeding under OPDR Act.
Yes.
And the remedies also lies in OPDR Act. He can move denial petition, he can file.
I had filed, that is rejected.
Denial, in fact, that was being
Rejected. Now, appeal also I can't carry under the OPDR. Why I am answering
So
my
this
lord?
is not a case of lack of remedy, because unless you challenge, OPDR authority cannot go behind and decide whether mining officer, Tahsildar, NGT, or for that matter any authority.
That-
If it is a demand, it is a demand.
On requisition, this proceeding has been filed.
And the demands raised, my lord, in terms of Rule 25 has already been paid in Annexure 3. They have collected it. So once that is collected, compounded, it cannot be reopened again. That is the law also.
Annexure 3 is dated 29/11/23.
Uh-huh.
The order of the NGT is 25 IC4/2025.
Sir,
So if that plea is taken before the NGT and still the NGT has not considered to prudent to say that because it has been paid on 29/11/2023, nothing is to be paid.
no, there the NGT doesn't say I am the guilty person. NGT
And
say,
NGT has said because I don't know what is the standard of proof or otherwise, but NGT has that Behra has been entangled actually. Behra has these that plot number 830 by 130 is nobody's plot. This is a government plot.
yes,
Mining should have been there, but there is a clear-cut finding from that plot. This mine sand have been extracted. If you go through that, there is a clear finding. 830 by 130, sand has been extracted.
by
Downstream, Behra is there. So he is the legal, he's the leaseholder, mining leaseholder for the downstream plot. But what has happened here, that in River Bahura, upstream, from that 830 by 130, there is extraction.
yes.
But whoever were gathered, they were very impressed with them. So they said that nothing is happening. But there is a factual finding, physically, the sand has been extracted.
But my involvement, my lord,
I'm only reading with you.
my involvement, local people say this. NGT
not
doesn't
in-
say, NGT doesn't say they recover it from DD.
So that you have to challenge actually.
No, sir, kali instruction देख रहा हूँ. Sir, in fact, I have paid.
Without at times after snake bite, the person doesn't know which snake. But if the person presumes that it is a non-venomous snake like water snake or rat snake, then it's a problem.
As I was submitting, my lord.
How
just
now?
I'll waste another moment, you, my lords. That annexure 3 I was showing to your lordship. At page 33. Your lordship may see Siripur name of the Moja from serial number 1 to 6. I am the person involved. DD builders at the end, my lord. Name appears. And I have paid, they have collected penalty.
That is the problem. You are a party of OP number 10 before the NGT.
Yes.
So what are your stand there in Annexure A/4? Whether you have taken that stand, what is the finding?
Vis-a-vis this, I am just showing I am educating myself. My lord.
That is the difficulty.
We can,
Educating tribunal is the difficulty. Now this High Court has much more difficulty being a read court to educate itself regarding Annexure A/4, page 33,
Sir,
which is not part of consideration by the NGT.
for general public interest, my lord. 51V. Where an offense,
Can never be general public interest. If you have taken that stand, what is the finding? At best, you can move the NGT. But I mean, legal remedies, so many that can be.
I'll come back to your lordship tomorrow.
I have done it, senior advocate, for the petitioner at length. The petitioner in the petition challenges the demand. Kindly take your seat. I'll take some time in dictating. Please take seat. Please take your seat.
May I leave my.
Yes, please. Yes. One second. Challenges the improved demand notice dated 26/6/2024 into bracket Annexure 4 and order passed by the certificate officer dated 28/5/2025 to bracket Annexure 10 passed in the certificate case number E/2024 dated 30/8/2025. Issued in the said proceeding. Challenging the said demand, it is submitted that the demand emanates from the direction of the not challenging Lekon. It is submitted that the demand emanates from the order passed by the lauded NGT order Yes, young man. NGT order ta kete page? On the NGT order dated 17/10/2023 passed by the order of the full form lekhantu, the National Green Tribunal, Eastern Zone Bench, Kolkata. Passed in original application number 153 of 2023. देखी लिखिए oblique 2023 oblique EZ page 23 देखी लिखिए हैला the senior advocate ऑर्डर कहते डाकली नहीं 22/4/25 पेज 43 सेंटेंस से कौन है takes this court through the said order. Stop. The petitioner hearing is OP number 10 before the allotted NGT. The NGT has recorded the inspection report of the committee members who had visited the site. The 47 Siripur sad आरंभ हुई की ही चीज तहसील चिकिटी सिरीपुर सैंड करी रिवर बाहुड़ा प्लॉट नंबर 1 पूरा लिखी कौन लिखले सेंटेंस से
Did the sites and the NGT has reported this one.
ई रिपोर्ट कौन आखिर पढ़ो सेंटेंस से
NGT has reported the report of the public members.
report furnished by the members of the committee constituted for the purpose of inspection after the site visit on 30/11/2023. The NGT has recorded the details of the members. Has noted the learned NGT has noted the details of the members who visited and their factual finding at internal page 6 and 7. Order into bracket page 47 and 48 of Annex 7 bracket closed. The conclusions and recommendations of the committee constituted for the purpose has also been noted by the NGT at internal page 7 and 8 of the judgment dated so and so. Date कुछ पाए आंसर था last page से date था judgment. The Lord senior advocate then refers to para 32 of the judgment dated 22/4/25 which is reproduced herein. 65 page रे अछि 32 paragraph. The original application to neki 33 रे अछि the starts disposed of accordingly. 32 33 quote कर देले. They submitted that as per paragraph Roman 3 of the direction, the director of Mines and Geology Department was to recover the penalty. However, in the present case, Tahsildar has initiated the proceeding for recovery. Is referring to the Annexure 3 dated 2023 of the writ petition, which is captioned as Nuapada Circle Enforcement into bracket 2021-2022. Particularly entry 33 कहले
33 sir.
33 टा कोठी पाइबे कहले
1 to 6 serial.
eh
33 रो 1
page
33 sir.
कौन लिखे particularly कौन इंग्लिश में तो कौन आंटी कौन क्वेश्चन को भाषा में entry number 1 TO26
1 to 6.
to submit that already for the said sand quarry he has deposited the amount he has paid the petitioner has paid the penalty
For towards transportation.
तो मु जाननी आप जानचंती दिव्य दृष्टि
Vehicle ଅଛି sir vehicle.
जजेस दिव्य दृष्टि नले जो कमेंट आछि non application of mine बाहर कहि परिबे जे डजंट अप्लाई सेटा किंतु हमर सुप्रीम कोर्ट जो आछि सेटा
नहीं सर नंबर ऑफ vehicle seized अछि तो सेत पे
सेटा सेटा जा अछि से अछि आ कोडा मु तो किछ आज कोनी सब्ट्रैक्ट भी कर
सर
कोन लिख collected by the authority as indicated in the said document into bracket annexure about 4 stop public এটা A/4 कर देले नहीं এটা annexure A/4 ता आउटे कोठी बोले लागितले annexure 4 annexure 3 बोले
Annexure 3.
3 annexure 3 annexure 3 in view of the challenge to the proceeding before the OPDR authority, the learned senior counsel was asked whether the petitioner had challenged the order of the NGT, judgment and directions of the NGT. That लिखिए पूरा टा जो in way number इतने नम जज ना जान पर नंद
Or number 153/23. Eastern Zone.
way number 153/2023/EZ dated होची 22/4/25 और the demand notice टा केबे 23/24 annexure 6
sir
ना आउ किछ अछि
demand 9,70,000 sir.
प्रथमे जोडा आपण कहउछन जे तहसीलदार कले किंतु माइनिंग ऑफिसर करिया कथा सेटा कोटा
এটা collector district magistrate করছন্তি annexure 4 series রে 4 page 36 through 40
କଣ ଲେଖିଲେ?
26/2024
Whether he has challenged, whether the petitioner has challenged, ସେଟା ପୁରାଟା ଲେଖିବେ। ଯୋଉ ଲେଖିଛନ୍ତି ସେଟା ପୁରାଟା ଲେଖିବେ। Dated ଏତେ and demand and the office letter 2057 dated 24/2024 issued by the
collector
executive magistrate na tahsildar by the tahsildar Chikiti
collector
into bracket annexure 4 collector ଆପଣ picture କୁ ଆସିଥିବେ certificate case ପରେ
collector ହଉଛି committee member
ନାଇଁ demand notice ଟା ମୁଁ ପଚାରୁଛି
sir ସେଥିରେ seal ମରା ହେଇଛି ତ ସେଥିପାଇଁ ମୁଁ ଭୁଲ ଦେଖି
collector
no that was appraising the court collector was why I said that I can't maintain an appeal
actually ମୁଁ page ଟା ଜାଣି ପାରୁନି ଆପଣ କୋଉ page
page 36 ରେ sir ଦେଖୁନାହାନ୍ତି ନା ଏଟା ଇସ୍ୟୁ ହେଇଛି ଇୟର ଅର୍ସି ଯାଇ ତହସିଲଦାର ଚିକିଟି କିନ୍ତୁ ମଝି ତା ଉପରେ ଅଛି ଗୋଟେ seal ପଡିଛି sir collector extend
ନାଇଁ ତ ମୋର ନାହିଁ
ନାଇଁ ସେଥିରେ ନାଇଁ ମଝିରେ towards the bottom ଏଥିରେ ତ ଅଛି ପେଜ ରେ sir ଅଛି ଇଏରେ
ସେଇଟା true copy ସେଟା ଆପଣ କଣ
ନାଇଁ
ହେଇଛି
sir ତା ଉପରଟା sir
ସେଇଟା not part of the document
collector ମାଝି ଅଛି sir ଏଥିରେ ସ୍କାନ ରେ ଅଛି
ଆପଣ ଜାଣିପାରୁନାହାନ୍ତି ତା ତଳଟା ପଢୁନାହାନ୍ତି ଉପରେ true copy ଲେଖା ହେଇଛି
ତା ଉପରଟା sir
true copy ଲେଖା ହେଇଛି ପରା ଆପଣ true copy ଟା ଭାବିନି issuing authority ଆପଣ ଯୋଉ ସେଇ ବହୁତ ଗୁଡେ ଡିମାଣ୍ଡ କୁ ରେଜିଷ୍ଟର କରିବା ପାଇଁ ବହୁତ ଗୁଡେ ରିଟ୍ ପିଟିସନ ଫାଇଲ କରୁଛନ୍ତି ସେଥିପାଇଁ ଆନେକ୍ସର ଆକ୍ଚୁଆଲି ସେ କରିନାହାନ୍ତି ସେ କୋଉଠୁ କୋଉଟା ଆଣିକି ଲଗେଇଛନ୍ତି ଆନେକ୍ସର ଆଉ has some advantage coming from that side has some advantage only
Then but just I think like the receipt which is I agree it was about
annexure 4 received by the petitioner और সেটা কেতে 1/11/24 7/24 1/7/24 ସେଇଟା ଆପଣଙ୍କ ଇନପୁଟ ଦରକାର ଆପଣ ବାପଟେ ଯୋଉ ରିସିଭ କଲେ ସେଟା 1/7/24 ଅଛି ସେଟା ସେଟା ତାପଙ୍କ ଦସ୍ତଖତ କି କଣ ଲେଖିଛନ୍ତି ସେଟା
receipt
ARSS ନା କଣ DD builder
receipt by ନାଇଁ this one except
ठीक ଅଛି ତ ରିସିଭର କାଟି ଦିଅ ସେ ଲାଇନ It is submitted by the learned counsel for the senior advocate that the petitioner has chose not to challenge any of these orders. Para. The learned AG in response submits that the petitioner submitted he has factual aspects. However, prima facie, the petitioner has to challenge the petitioner has to take the pleas before the authority, before the certificate authority. Stop. At this stage, the learned senior advocate seeks adjournment to obtain instructions from the petitioner. କେବେ ଆସିଲେ ହବ କହୁଛନ୍ତି
କାଲି ଆସିଲେ kind of sir କାଲି
ସେ ତ ଆପଣଙ୍କର
9 ତାରିଖ sir ନହେଲେ ଆସୁ
list in the commencing 9/3
10 certificate of CORAM ପାଖରେ ନହେଲେ ଆସୁ
ଏ କାଲି ବି ଆସିପାରିବ ଆପଣ ଚାହିଁବେ
ତାଙ୍କ ଉପରେ
ସେ ତ instruction କିଛି ନବାର ନାହିଁ because you have to first appraise this court whether you have challenged or not. As it seems, it has not been challenged.
sir କାଲି ଆସୁ ତାହେଲେ
ठीक है तो list tomorrow.
may pray the order may be uploaded if possible.
Let us see. Say that
more sir now the matter is over. Why can't file an appeal also? Reason being collector was the party before the tribunal.
Sir, that's a very good ground to move. Not challenging the order is the question. NGT Maybe I don't know whether High Court has jurisdiction.
High Court.
Tahsildar order whether has jurisdiction. All those orders have to be challenged. Unless those things are challenged, this certificate authority or the court now considering the certificate proceeding has very little scope of, interfering also.
If I question the Tahsildar's order again, I have to come to your lordship.
No, I don't know. Maybe the same assignment. Maybe I don't know whose assignment it is.
OPDR पर आपनकर
OPDR केमती से तहसीलदार करा होगा. तहसीलदार को OPDR order no सेटा. अपना illegal extraction of sand from Siripur's sand bed under Chikidi Tahsil.
that also your lordship.
So that's not OPDR. 26/24 सेटा ହେଇଗଲାଣି almost it will be completing 2 years now. ଆପଣଙ୍କର OPDR notice are much after that.
Yes, yes.
23/24 ବୋଧେ OPDR ଆପଣଙ୍କର.
ଆଜ୍ଞା.
ଆପଣ 26/6 କୁ ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି.
କରି ତ ନାହିଁ ସାର୍ ବୁଝିବି ସେଟା କଣ କରିବି।
Yes, next.
Item 4.
Sujata Jena for senior advocate along with Ms. Sunali Ponda for the petitioner. Yes, Ms. Sir.
My lord, I have challenged the order passed by the learned court below in granting ad interim maintenance of rupees 5,000 in favor of the opposite party. Your lordship told to lordship's order dated 3/2/2024.
Yes.
Pursuant to which I have filed an affidavit.
Yes.
Right now,
Details I'm not getting. You have gone through the three paragraphs because the order is very specific.
yes.
Petitioner shall file affidavit indicating the details of orders passed, amount directed, and details of payments.
And
So you make it a simple table.
yes.
Because I have by which order, how much is paid, and maybe details. After that, the details. Or suppose he has paid every month, it's the second column, then third column is the total amount.
Actually, in this case, I have reviewed from your lordship may kindly turn to
The details of orders passed is not there, amount directed is not there.
କେବଳ ଏଇଟା
Upon
ଅଛି।
3/2026 ରେ।
ଆଜ୍ଞା ମୁଁ ସେଇଟା
ସେଇଟାକୁ ଲଦେଲେ ମୁଁ further proceed କରିବି।
କେବଳ ଦେଖୁଛି ଆପଣ ଟିକେ ଦେଖନ୍ତୁ।
ନାଇଁ ଆପଣ 2ଟା comply କରନ୍ତୁ, is your choice or take action. I cannot read my order.
No, I am not, my lord.
So by which you filed, kindly read paragraph 1. He submitted, see, 3 times. He submitted by the learned counsel for the petitioner that petitioner is paying the amount as directed by different orders by different. Then para 2. Accordingly, it is directed to substantiate the statement. Petitioner shall file affidavit indicating the details of orders passed, amount directed, and details of payments.
That's okay.
So this much.
That I do.
Because the problem is that I cannot decipher by reading it.
I don't say so also. Only I want to impress your lordship on order dated 8/9/2025 since which date I have started paying.
Madam,
ମୁଁ ବୁଝିଗଲି ଆପଣ ଯାହା କହିଲେ।
ଆପଣ ବଢିଆ ସେ ବୁଝେଇଛି ଆଗରୁ। ଆପଣ ବର୍ତ୍ତମାନ ଯୋଉଟା କହୁଛନ୍ତି, you need not to tell me even, because if I prepare that table that way or the affidavit, this is the amount, better table are formed. Could be that. So that is how, in fact.
Lordship may keep it to 10 or 11. 11.
We commencing 16th or 9th.
Oh.
The Lord Senior Advocate refers to the order dated 3/2/2026, passed by this court earlier, and submits that affidavit on behalf of the petitioner has been filed. Having gone through the said affidavit filed by the petitioner dated 25/2/26, the order dated 3/2/2026, particularly paragraph 1 and 2 are reiterated. So the petitioner shall file affidavit indicating the details are specified in order dated 3/2/2026. And the other problem is that when they are telling the lawyer also, they are not telling the exact facts. Yesterday, somebody saying, this fact has happened, maybe you were present. After the decree is passed, I have deposited in Sukanya Samruddhi Yojana of Government of India. So then at least the submission to be, made legally, then I have to record that deposited in the compliance of the decree. So that will be too far stretching the order. Now maybe the court is at times, we have passed orders. Make a whole health insurance, make a fixed deposit. All those things can be done by the court. But if a decree is there and it has to be complied with, then I suppose in fact I asked that whether you have paid what they give to the daughter. You are not authorized paying, but what they give 1 lakh. Can this court take note of that? And difficult part also. So that they and then there is change of counsel. Second counsel is seeking time. So this is the process they are adopting. And they are not encouraged by the trial court lawyers, most likely. I have to say this in open with some responsibility, because I have seen, along with you also, you appear in so many matters. This anxiety expressed by the Supreme Court, that regarding 125 awards and all these things, after so many years of Rajneesh versus Neha, and which has been circulated to all the courts, to be circulated to all courts. Then Rahul Shah, execution, 3-judge bench. Still their struggle is continuing. And when notice is issued to the wife, she doesn't come because she thinks that what she will get by engaging a lawyer, because she is already struggling to enforce the earlier decree.
That is there.
That is the major challenge now. And that is how the whole thing is getting stuck.
That is there. Okay.
So once you ask them, you file affidavit, then they will put terms to the, at least to the lawyer, they will tell, yes, I have paid this much and this has been done.
Okay.
Mr. Samal?
Yes, sir.
List in the week commencing, sorry, with the 13 week, na? Quebec upon Quebec kuchundu. Date ka dina hai.
So,
List in the week commencing 16 kuchundu. 30 नहीं परिवार ना 16 करियो 16 16 से 80 टा देखो छु दिना से वीक नहीं ठीक अछि डिस्ट्रीब्यूट करिवे
आज्ञा
যদি 30 দিন হবো তাহলে ঠিক আছে 30 দিন 31 টা আছে yes
Madam, I
Complied, man. We complied affidavit we have filed.
copy sir
Yes.
yes Mr. Samal, have you been served with copy? Mr. Ranjit Samal for the petitioner, Mr. D.N. Lenka, AGA for the opposite party. You take your seat. I'll take some time in dictating the order. The learned counsel for the petitioner refers to the order dated 2/2/2026. To submit that the opposite party has to file affidavit regarding compliance of the order dated so and so
27/10/20. Annexary
12/5/23 sorry 36/10/22 passed by the coordinate bench in WPC number 27842 of 2022 page 12 range. Para. The learned AGA submits in response, the learned AGA submits that compliance affidavit sworn to by the OP number 3 has been filed. Copy of the affidavit has been served with the learned counsel for the petitioner. The affidavit is a affidavit filed by the OP number 3 is on record. Date ta hochi taro 26/2/2026. Stamp bhi korna hai. 26/2/2026 has been is on record. In the said affidavit, the details of the compliance, details of the steps taken for compliance have been indicated. The document has centered on the unconditional apology. The spelling mistake है unintentional है negative है अपन page 6 देखो page 6 para 14.
Yes, sir.
Third line.
Delay
पढ़ुनांती.
It is only submitted that this deponent has highest regard for the orders passed by this honorable court and never ventured to violate the orders of this honorable court at any point of time. The delay caused for non-compliance of the order of this honorable court is bona fide and this deponent makes on intentional apology.
So now he has to make unconditional apology for writing, tendering unintentional apology and the delay. That I wanted to show you. If the apology is unintentional, then what is the point?
No,
Or like
typing of that.
As unconditional apology for the delay in complying with the order. It is submitted by the learned AGA that inadvertent typographical error has crept into paragraph 14 of the affidavit, compliance affidavit, wherein instead of unconditional
Typed out.
within quote instead of unconditional within quote unintentional has been typed, which may be read as unconditional.
Yes.
Yes. See, pile na pile ni.
No, reject from that.
Reject collect. In view of the above, the petition, CONTC petition is dropped. The petitioner shall have liberty to challenge the order dated
24/2/2026.
24/2/2026 passed by the OP number 3. Annexed to the Shoko's affidavit marked as Annex A by 3 on its merit. Yes, next.
6.
Yes, please.
Not petitioner in this transfer petition.
Not maintainable. In view of the section 477, subsection 2 provision, the same sessions, the same session code you want.
Have you checked that? You are Mr. Anwar Hussain.
Yes.
Mr. Anwar Hussain for the petitioner. The DN Lenka AGA for the opposite party.
Sir, this is
Sorry,
item 6. Item number 6.
Yes.
Item 6.
Upon Anwar Hussain.
And Aditya Mishra,
Yeah.
Mishra.
So that is because Anwar Hussain is in record.
Yes.
That is how I asked. That's the context. Mr. Aditya Sundar Mishra.
Aditya Sagar Mishra.
Mr. Aditya Sagar is Aditya Sagar Mishra for the petitioner. Mr. DN Lenka AGA for the opposite party. AGA for the OP state.
Yes, sir.
Please kindly refer to 407. Have you got the book?
No, sir.
447.
447.
May I read? I'm happy.
Yes, ma'am.
Yeah, please. It is. What boss is it? What is boss?
Which one?
The Lord AG refers to section 447.
Subsection 2 provision.
Subsection 2 provision. So, Mr. Dekhile,
Sir. 407.
that's your 447.
This is This is
CRPC रे केते सेटा
407.
Right, BNSS.
এটা তো ইনিশিয়েটিভ কি CRPC রে
407.
407.
407
Yes.
CRPC since repealed and substituted by parametric provision section 447 section 447 in BNSS bracket closed. para joটা আছে 407 power of high courts to transfer cases and appeals dash into bracket 2 quote করতে হবে to provide you there is a specific bar to examine this or you want to take a chance read it. The Alliance Counsel for that matter shall be listed in the week commencing.
Page 3.
23-20-26. ଆପଣ ବହିଟା ଆଣନ୍ତୁ yes सीट रखुनाहांती ଏଇଟା ହେଲେ କଣ ଆପଣ ବଢେଇ ରଖିବେ ନେକ୍ସଟ ପ୍ଲିଜ ଡାକନ୍ତୁ
Item A.
yes madam
My lord, on behalf of Mr. R.K. Pradhan, this matter is about to challenging of the judgment number.
your name madam
Janayatri Raut.
sorry
Janayatri Raut.
Janayatri
Yes, madam.
Janayatri is name of a character in God does it mean
Goddess. Yes,
goddess
goddess name Janayatri.
goddess Janayatri Miss thank you Miss Janayatri Raut on behalf of R.K. Pradhan for the petitioner yes what do you want what the petitioner wants why
Challenging the order dated 17 January 2026, Annexure 1,
yes
where the petitioner is disallowed for maintenance. Petitioner number 1.
which part it has the court has disallowed the maintenance to number 1 because ordering portion you find at page 32
My lord,
32 order
case number 32.
yes order in view of the foregoing discussions kindly read পড়ন্তু সেটা
There has been mentioned that the OP party is
kindly read the entire thing
Yes, my lord.
don't split the sentence you read in view of the foregoing discussions
Yes, ma'am.
kindly read that
The OP party is directed pay rupees 5,000 per month to the petitioner number 2 as the maintenance by the 10th of each succeeding month. Such amount of the maintenance shall be payable to the petitioner number 2 for the date of filing of the application, that is 2 April 2025 till the attendance.
till he not the till he say
Yes, ma'am.
he must be he's a boy yes. Now my question to you after going through this that acha at the same time the last 3 lines can you read the last 3 lines at the same time for discussions made above that page 33 briefta jahale bhi sabale पढ़ी देबे
At the same time, for discussion made above, the petitioner number 1 is not entitled to any maintenance. However, there shall be no order to order as the cost.
the reasons
Uh, My lord, ground they mentioned that
ground no आपण आगे देखिए impugned order रे कोर्ट कौन ଦେଇଛନ୍ତି finding
yes, my
सेटा कोठी अछि देखंतु that you find at your running page 28 देखंतु
yes, my lord.
28 internal page 13
Yes, my lord.
about 10 lines on the bottom. It is true that finally matrimonial home on
Yes, my lord. It is
I have
that the petitioner number 1 has lodged a FIR against the OP party alleging the demand of dowry
opposite party.
and a cruelty melted out in connection with such demand of dowry, which has been marked as a
exhibit P-1 P1 yes.
When the mere filing of the FIR does not by itself prove the allegation made by the petitioner number 1. My lord,
then read further. The region been completed. Read further. Even otherwise,
the extended P1 also nothing has been stated as to what happened on or immediately prior to 23 December 2024, which compelled the petitioner number 1 to leave the matrimonial home.
yes.
In view of the aforesaid discussion, it has to be held that the petitioner number 1 has got no sufficient reason to stay separately from the opposite party.
Then you are missing the crucial part. Don't turn your pages. Page 29 after जानतु छाड़ देले से लाइन टा छाड़ देले अपन.
Section
Yes.
144 subsection 4 of BNSS provides that a wife is not entitled to receive any maintenance from her husband under section 144 subsection 1 if she refused to live with him without any sufficient reason.
So that is so. What was your evidence to leave the matrimonial home?
My lord.
Examine question. I am issuing notice, but you have to develop a habit of reading a brief.
Yes, my lord. My lord, page number 90.
It cannot be that without referring to 144.4 and 144.1, it will argue the matter.
Yes.
Have a bare act at hand. Read it. What is the thought of the court? What is the court as? You have to challenge it.
Yes.
Because unless you know what the court has, what reasons the court has given, how do you argue your point? So your argument would be that this is not a case of voluntary desertion. This is not a case of voluntarily the wife has sufficient reasons. The court has not believed that. So then you have to examine what material apart from, suppose now the court has given a finding. By simply filing a FIR cannot be a sufficient reason.
Yes.
Whether have you adduced any evidence? You yourself have stated. So that would be your argument before this court. That to dislodge my statement that I have not left my matrimonial home voluntarily, there is no examination of any witness or the husband has not stated anything. The wife would have been asked regarding that. What is the response? How she has stated in her examination in chief. Examination in chief, the person who is asserting, he is stating that here it is C. So those things you have to make your argument, sir. The petitioner wife is before this court. Now you take your seat. I'll dictate the order. The petitioner wife in the marriage is before this court. Take your seat. Along with the minor child, about 7 years. Why the child is challenging after it is granted, unless it is for seeking enhancement of the child, because 7,000 has been granted to the child, 5,000 has been granted. You are seeking enhancement. You should not have collect. Stop. The challenge is to the judgment dated 17.01.20226 passed by the Learned Judge, Family Court, Dhenkanal. It's CR.P. number 55 of 2025. Stop. By the said order, the prayer made by the wife seeking monthly maintenance under section 144 of BNSS at rupees 33.0 per month was rejected. However, the minor child, the minor son born from the wedlock has been granted maintenance of rupees 5,000 per month to be paid by the opposite party husband as father. Our Learned Counsel for the petitioner submits that the judgment denying grant of maintenance, monthly maintenance under section 144 is contrary to the material on record as well as settled proposition of law. Para. Issue notice along with this order. Stop para. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. Stop. It is further directed that the petition number 2, minor son shall continue to receive the maintenance directed by the Learned Judge, Family Court by judgment dated 17/1/2026 without prejudice to the rights and contentions of the petitioner number 1 in this petition. Yes. Next.
Item 9.
Yes, please. Mr. Bibhu Prasad Mahanti for the petitioner.
Here the present.
Even Loveliness marriage has failed.
Yes,
and he has so Bibhu is unable to do anything. The names are interesting. Chandan invites Bibhu to do something. Chandan marries Lovelina. The marriage fails. It is without love.
It was an arranged marriage. It continued only for 7 months only. They have married in the year 2018, 8/5/2018, and they have separately living since November 2019. This proceeding was initiated by the wife in 2022 under 125. Now the petitioner is challenging the final order of maintenance passed by the Learned Judge, Family Court, Bhubaneswar, fixing the.
So you just give the details of payments already made.
My lord, I have also.
And how you will secure.
Yes, sure. My lord, I have also.
Have you any reference to that? Any?
Next, all the DDs from the day one of.
Not. Don't do that.
My lord.
You do the exercise of arriving at the figure.
Okay.
Because it becomes very confusing and it may be erroneous also.
I follow your lordship's directions. I'll file an affidavit, strictly with the affidavit.
Suppose you have already it is on record.
Yes.
You make a summary of that.
It is not on the record, your lordship.
Oh, then it has to be right on record.
I have only filed the DDs, but in the order sheet judgment, it is not been reflected. Though it has been put in the cross-examination to the witnesses to the PW1.
No, DD means it would have been received by the wife.
Yes, yes.
So that you say.
That I have also.
When she received that amount, what is the amount?
75,000.
So whatever, so what is the date of direction?
My lord.
And when you started paying?
That I have mentioned.
So that you prepare that.
My lord.
Can it be tomorrow? Simply adjourn.
I have also mentioned in my pleadings itself, if your lordship will go through the date of order I have mentioned. Page, my lord, at para number 16, page number 5, para number 6, my pleadings before this.
Yes, page 5.
Page 5, para 6, your lordships. Without, however, my lord, the relevant portion, middle portion, have the learned court below without taking into consideration of the objections by the order dated 10/2/2023 allowed the application of the opposite party, directed the petitioner to pay interim maintenance of rupees 20,000.
Correct. What you have stated is that, but my point is that after the final judgment,
My lord.
direction, it is a judgment in fact.
My
So there will be a differential amount.
Ha.
So what is the date of application now after Rajnish versus there? Date of application.
Date of application as per the court, it is that 30/9/2022 is the date of application. Court has passed the order only that you have to pay since 30/9/2022.
Right. So those details you just make so that my order doesn't suffer from factual errors.
I'll file an affidavit.
So factual error is not necessary.
Yes, sir.
It should be always avoided.
My lord, I'll follow your lordship's.
You want it tomorrow?
Day after
Monday week.
Yes, sir.
9th week or 16th week?
9th week, your lordship. Or 16th, your lordship, the better fit.
As paid for by the Lord Counsel for the petitioner, the matter shall be listed in the week commencing 16th March 2026. On the same date, the affidavit be filed by the same date. Affidavit be filed indicating in a tabular form the details of the payments made. And the details of the order directing payment of maintenance oblique interim maintenance. Then details of payments made. Amount due to be paid pursuant to the impugned judgment dated 20/12/25. It seems he has paid.
Yes,
he has been paying. So that you should have, you have to leverage that.
Well,
you have to leverage that.
Only I'll put the figures in.
Figures and in a tabular form so that to when he's supposed to pay and how much he has paid.
Well, my instruction that from the day one, because I was the conducting counsel in the lower court also, my lord, from the day one of the application, we are paying, and 6,75,000 has already been paid. It is almost.
So now the question would be, what is the court? How much the court has directed? And
There
how
will
much
be a
is
differential amount of 1 lakh,
differential something?
1,30,000 differential amount.
So we prepare that.
Yes, your
Prepare that. Yes, liberty to mention. So it will be listed for fresh admission.
Yes,
it is for fresh admission. What will be listed for fresh admission? Yes, next.
Yes.
So Deepak Kumar Sahoo for the petitioner.
Item 10.
May I please, your lordship?
Yes.
My lord, petitioner before your lordship is the wife and opposite party is the husband. This present petitioner filed this application for transfer of the CP case which has already been filed by my husband opposite party number 1 before the judge family court Bhubaneswar. That CP suit number 729 of 2025 from Bhubaneswar to Kendrapada. Because my lord, on the ground that marriage was criminalized, my lord, in the Kendrapada, in the district of Kendrapada in 980 place. And after marriage, my lord, that the present petitioner was resided in her father's house and in the place that is the Bangalore, in the service place of my husband. Thereafter, some disturbances took
place. But how this court will determine that unless you take that plea before the trial court? Look at section 19.
Only, my lord.
If you look at section 19, and the pleadings of the petitioner there in the trial court, then you will able to realize that this court doesn't have jurisdiction to decide the jurisdiction, territorial jurisdiction here.
Because, my lord, I am a lady. And, my lord,
No, there is no provision that the place of the lady, the suit has to be initiated. Thank you.
My lord,
Are you having
difference between, from, my lord, from my native place to Bhubaneswar is, my lord, more than 100 kilometers. And now, my lord,
you have to avail ICT.
and my
So
lord,
you see, by simply transferring the case.
another case, my lord, which I have annexed in Annexure 2, another CP is pending before the Judge Family Court Kendrapada.
When did you file? How many cases you have filed against your husband?
One CP that is for maintenance under Section 144 of the Venice Act, my lord, I have annexed in
So,
Annexure 2.
maintenance, so when did you file that?
That it has already been filed on,
You see, because Mr. Sahoo, the problem is that
my lord,
how does this court take evidence without the pleadings? Because
that will be-
you look at Section 19. ওরা বয়ান আনছে না দেবী? আমি দিউন।
Section 19, my lord.
দেখুন পড়েনি কত
To which petition shall be presented.
Yes.
Every petition under this act shall be presented to the district court within the local limit of which ordinary original civil jurisdiction. The marriage was solemnized first.
Yes.
The marriage was solemnized, my lord.
Can you read? Don't add your commentary.
My lord.
ଆମେ ଯଦି ମୁଣ୍ଡା ହେଇଯିବା କେମିତି ହବ? ଆମେ ଆମର ପଢିବା
ଆଜ୍ଞା
ତାପରେ ଯୋଉଟା ବୁଝିପାରିବନି ମୁଲାଙ୍କୁ ପଢିବା. But how does it make if I and you both being Sahoo will add our commentary? Can you read it alone? ମୋ ବହିଟା ପାଉନି ଅଛି ସେଇଠି ଅଛି କି ସେଇଠି ତଳେ ଅଛି ଅଲ ଇଣ୍ଡିଆ ଲ ରିପୋର୍ଟ ତଳେ ଦେଖିଲେ ସରୁଟା ନା ଆପଣଙ୍କ ସାମ୍ନାଟା ଅଛି ପତଳାଟା ଦେଖନ୍ତୁ ସେଟା ନୁହଁ ପତଳାଟା ଏମିତି ହବ ସେଇଠି ଆପଣ ହିନ୍ଦୁ ମ୍ୟାରେଜ ଆକ୍ଟ ଅଛି now the point is like this
ମୁଁ ପଢିଦଉଛି
so please ବନ୍ଦ କରିଦେଲେ ବୋଧେ ଆପଣ କନସେନ୍ଟ୍ରେଟ କରିକି
ନା ସହଜ ଥିଲେ ମୁଁ ସେଥିପାଇଁ ବନ୍ଦ କରିଦେଲି.
I can speak from my memory also.
That every petition under this act shall be presented to the district court within the local limit of whose ordinary original civil jurisdiction. The marriage was solemnized.
Yes.
Or the respondent at the time of the presentation of the petition resides, or the parties to the marriage last resided together.
Now look at your petition.
Again.
Correct.
Again.
Now read your cause stated. Versus Sunil Sagar Nanda, village Ghatikya, Bharatpur, Bhubaneswar. Now look at the plain copy in city.
Again. That paragraph 3.
Paragraph 1 ଦେଖନ୍ତୁ ସେ କେନ୍ଦ୍ରାପଡ଼ା କହିଲେ paragraph ରେ ସେ କହିଲେ ଯେ ବାହାଘର ହେଇଥିଲା ସିଏ କୋଉଠି ସିଏ ଯୋଉଟା ଆଲେଜ କରୁଛନ୍ତି ସେଇଟା ଦେଖନ୍ତୁ ସେଇଟା ଦେଖନ୍ତୁ
ତାଙ୍କ ପିଟିସନ ଟା
ହଁ ତାଙ୍କ ପିଟିସନ ରେ ଜାଣିବ ନା
after marriage both the parties were resided at Bhubaneswar. Thereafter some days they went to Bangalore.
So that is the difficulty, sir. Now this plea you take before the trial court, it will be dismissed. You understand?
No, in trial court, no, nothing has been dismissed.
You are not following that. Shunantu aga. If you take the lack of territorial jurisdiction before the trial court, the suit will be dismissed or will be allowed. By these points, suit will be dismissed. So that is as good as you winning the case. Why this court will transfer for trial at Bhubaneswar, Kendrapada?
Because, my lord.
You are not answering, sir. You are stopped somewhere. You are saying that the nothing has been dismissed. Is it the question to you? What has been dismissed?
Now, your lordship was asking me to file an application before the judge.
Whatever, sir. How this now
Round of jurisdiction.
so now this High Court, how it will arrive at a conclusion that you stayed at Bangalore and Kendrapada without anything being framed? It's a question of fact.
My lord, if we will analysis the section 19.
Correct, sir.
Paragraph 1, Roman 1.
Correct.
The marriage was
Students say problem over. Following section 19, how can I determine the jurisdiction? Because I will say that they say that they stayed at Kendrapada, they stayed at, so that argument is incorrect.
My lord,
they stayed at Bengaluru and they at Kendrapada. So this filing has to be
difficult. It is difficult for this honorable.
Not difficult.
Conclude.
Difficult, Mr. Sahoo, it is illegal.
Illegal.
Because this is a statement and counter statement. The court which has it, now look at CPC, section 9. ଆପଣ ଅନ୍ୟ କ'ଣ argument କରିବେ ନା ଆଉ?
My humble submission that
am I not humble? I'm more humble than you.
Petitioner before your lordship is a lady. At present, she is residing in her father's house.
Don't show that in section 19, the petitioner's place has to be chosen. That is not there. You are not reading section 19.
Section 19.
You are relying on 19, reading 19, and arguing a point against you.
No, my lord.
Because if you are making a statement before High Court that we do not stay at Bhubaneswar, how this court will adjudicate the factual finding?
No, my lord.
So now you suppose, now let me, Mr. Sahoo, you will now maybe perhaps I have to present it to you in a different way. I direct transfer of the case to the Kendrapada.
Again.
So what will be the consequence?
That these two cases will be tagged up and this.
Not two cases tagged up, that's a different 125 has nothing to do with section 9.
The benefit of the parties.
Benefit of the parties, so 125 is a different. It is not to be tagged up with any other matter.
Again.
Section 9 can be tagged up with a 13 application. That's a wrong statement. Misconception of law.
Two cases will be, my lord, proceeding.
9 they confine karantu. What would happen to section 9? You will join the matrimony or you will register joining matrimony?
That in consolation, my lord, that result will be.
So then you are not, so then it has to be adjudicated by Kendrapada?
Yes, my lord.
So if it is dismissed at Bhubaneswar, what is the difficulty for you?
No, I have to present before the.
Obviously. How can I know that?
Now, my lord, I have.
The problem is that you find out a case law that section 19 has been interpreted that where the wife decides, that will be the place. Or Supreme Court has said section 9 has to be at the place of residence of the wife. It is not there. And suppose you now file, because you are a better person, not Mr. Sahoo, but I mean your client. She doesn't file cases. In most of the cases, the helpless ladies, they file 5-6 cases against husband. Since I have filed 498A, I have filed 307, I have filed domestic violence case against my husband. Wherever he files the case should be transferred to my place. There is no provision in the law.
No, my lord.
You examine that section 19 is actually against you.
No, section 19, my lord. That this act shall presented to the district court within the local limit of whose ordinary or original civil jurisdiction. 1. The marriage was solemnized.
ଆପଣ ପଢିଲା ପରେ ଆପଣ ଯୋଉଟା ପ୍ରୋଭାଇଜୋ ଆଡ୍ କରୁଛନ୍ତି,
marriage was solemnized in my father's house.
ଆରେ ସେକେଣ୍ଡ ଟା କ'ଣ ହେଲା?
Second, the respondent at the time of presentation of the petition resides or that this present petitioner is at the time of
ଯୋଉଟା ଫେଭର ରେ ଅଛି ସେଟା ସିନା ପଢୁଛନ୍ତି, ଆରଟା ବି ପଢନ୍ତୁ।
ସବୁ ପଢୁଛି ଆଜ୍ଞା ଗୋଟେ କରିକି।
ଆପଣ even not getting
present petitioner is resided at Kendrapada, district of Kendrapada.
Three to marriage,
parties to the marriage last resided together.
এটা or না and ଅଛି।
Again, the parties to the marriage last resided together.
Or na and ଅଛି again। So 3 is satisfied
resided lastly.
সেটা কি ডিসাইড করিব?
That is state. My husband has already admitted, my lord.
Sir, সেটা আপন
kind of a glass that annexure which has already been issued to me in the notice that my husband in paragraph 2 has already admitted that after marriage both the parties.
The High Court will decide that CP.
No, my lord.
That you have to answer.
Only humble submission. She's a lady. She's a lady.
So that submission.
She has not received a single pie from the husband.
Sir, not receiving a single pie, the matter has to be transferred to a case law. You must understand that.
Because
by delaying the process of adjudication, where you are arguing a point in your favor. So 3 is satisfied. The High Court will say that 3 is not satisfied.
No, खाली
I'm
not saying
either 1, 2 and 3 or 1 or 2 or 3.
my lord,
So you showed me the provision in 19 where the residence of the wife is material in 19. I'll decide.
My lord.
It is not that I am telling you.
My lord.
Though it looks as if I am telling you, but you are doing. Because 19, the matter has to be transferred to from Bhubaneswar to Kendrapada. Where is that?
My lord.
Which provision?
My lord, my humble submission, my lord, I am not saying for dismissal of the case which has.
You are not getting it, sir.
You are
who is asking you for dismissal?
No, I am.
Suppose you are saying that the case is before the family court, family judge, and the Bhubaneswar.
As per the
who will decide?
Subclause 1, subclause 2, subclause 3 of section 19, my lord.
Who will decide that?
I have this application on my lord.
You will not answer. You must say that I will not answer.
No,
That's
no,
it.
my lord, no, my
You
lord.
will decide that. Not maintainable before the trial court, before Bhubaneswar.
Because, my lord, as per the provision.
Decide. Who will decide your plea that the suit is not maintainable at Bhubaneswar? It is maintainable at Bangalore or Kendrapada? Who will decide that? Now the problem is you have opened the Pandora's box. How the High Court will direct it to be at instead of Bangalore at Kendrapada? Because who is there?
My lord, he has not filed any suit at Bangalore.
Sir, he has not saying thank you. Problem. You are saying that it is you are staying. 2 is at Bangalore last decided, marriage at Kendrapada. But High Court will say since you are residing at marriage at Kendrapada, only Kendrapada jurisdiction, because I have to reject that contention. His contention.
That
Now you have not read or now read. He has clearly stated in the suit that last decided. Then how High Court will decide that he resides in Kendrapada?
On that point, my lord,
so you have to argue something else other than 19.
Something else to argument karuch. And my lord, my argument before this honorable court that petitioner is a lady and she is.
Sir, so that from a decision.
Residing.
Sir, I have been requesting you for half an hour. When the lady is party, the suit has to be there at the place of her residence. Section 19 of CPC. Or a case law. Supreme Court has decided it is binding on us. It is 141. Everyone, on both the parties as well as the court.
Because I have moved the case.
No, it has to read section 5. Because this creates a situation where I have to pass a illegal order deciding the jurisdiction of a court on section 19, which is a matter of trial. Section 9 lekut. Eda niyo. Saan ko diyon today?
Court to try all civil suits unless bad. The court shall, subject to the provision herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly bad. Explanation. A suit.
So leave it there. So it is a nature of it is a civil suit. CPC is, as far as jurisdiction is concerned, section 19 is territorial jurisdiction.
Okay.
Now, if you read with section 19 with 9, who will decide it? High Court. Because the wife says it is gospel truth, because the husband on oath has taken the petition.
We have.
Then what is your answer to? Then what is your answer?
Answer, my lord.
No, kindly look at the pleadings. Then you give an answer.
Yes, my lord. I have filed this application under section 24 of.
Correct, sir. Correct.
Yes. 24 of the.
Yes.
If your lordship will kind of have a glance to this is the provision. What are the basic ingredient? Why the High Court will interfere that on that order? That it is the ground of transfer, generally based on the interest of justice, such as judge being personally interested in the case, or
ଆପଣ ଷ୍ଟେଟ୍ ଶୁଣନ୍ତୁ ମତେ କ୍ଲାସ୍ ନେବେ ପରେ
hardship to the
ସମୟ ନାହିଁ ନହେଲେ କୋର୍ଟ ଟାଇମ୍
hardship to the parties because
ଶୁଣନ୍ତୁ ସେଇଟା ସେଇଟା
it is
24 ର କୋଉ ପ୍ରୋଭିଜନ ଟା ଆପଣଙ୍କର ବେଷ୍ଟ ସୁଟ୍ କରୁଛି ସେଇଟା ପଢନ୍ତୁ ଆପଣ ତ ସେକ୍ସନ 9 ସାଇଟ୍ ହିଁ କରୁନଥିଲେ ତାହେଲେ ଆଇ ହାଭ୍ ଟୁ ଆସ୍କ ୟୁ ଯେ ସେକ୍ସନ 9 ଦେଖନ୍ତୁ ଯେ ଦିସ୍ ହାଇକୋର୍ଟ କ୍ୟାନଟ୍ 24 ର କୋଉଟା
section 24
କୋଉଟା ବେଷ୍ଟ ଆପଣ ଫେଭର ସେଇଟା
to the parties
କୋନଟା
hardship to the parties
ପାର୍ଟିସ୍ ଆପଣ ହାର୍ଡସିପ୍ ଦେଖିଲେ କଣ ନା
hardship
ଆପଣ ନାଇଁ ଆପଣ କହିଲେ
ମୁଁ ଆଜ୍ଞା ଜଣେ ଲେଡି
ଆପଣ
ଭୁବନେଶ୍ୱରରୁ ଯାଇକି ମୋ ଘର ପାଖରୁ 100 କିଲୋମିଟର
ସେଇଟା ଆପଣ ଷ୍ଟେଟ୍ ଆୱେ କେସ୍ ଲ ମତେ ଆଣିକି ଦିଅନ୍ତୁ because of section 19 criteria ଆପଣ ଯଦି 24 ରେ hardship to the parties କହିବେ
ଆଜ୍ଞା
ତାହେଲେ you show that case law
ମୁଁ ଆଜ୍ଞା ଦେଖି
yes
ଆଉ ମୋର ଆଜ୍ଞା ଡିଷ୍ଟାନ୍ସ ହଉଛି more than 100 kilometers ମୁଁ ଆଜ୍ଞା unemployed now I am depending upon my old parents and I am an extra burden to my family and ଆଜିକାଲି କା brother ଆଉ sister in law your lordship know
hardship to the parties it is not a to a particular party ଲେଖା ହେଇନି hardship to the lady ଲେଖା ହେଇନି must understand
my lord
ଭାଇ ଆପଣ ଯୋଉ କହୁନାହାନ୍ତି କି that you court will be tilted towards one particular party a person as for you employed in Bengaluru will be asked to go to Kendrapada
ନାଇଁ
that is not you see kindly read slowly then you will understand
ନାଇଁ ମୁଁ କହୁନି କି କେନ୍ଦ୍ର
ଆପଣ ପଢି ଆଜ୍ଞା ସବୁ କଥାରେ କଣ ଗୋଟେ କଥା କହୁଛନ୍ତି ଆପଣ ପଢିବା ଅଭ୍ୟାସ କରନ୍ତୁ
ଆଜ୍ଞା
hardship to the lady
hardship to the parties
so petitioner is party to the then
lady
then that is the reason the many of the cases
it is hardship
you will not listen as the problem how many cases have you seen that why the Supreme Court is not transferring like this interstate hardship to the lady parties
lady
because it is not saying lady you are reading it as a lady
yes no that is parties not I am
so now why the Supreme Court is saying that you participate but you apply for the ICT virtual hearing virtual deposition the reason being by this is an endless process the person works in Bengaluru you are saying he doesn't stay in Bhubaneswar you do not stay in Bhubaneswar but he will be complaint only looking at hardship of a particular party that the suit will be transferred and now yet the issue is to be framed whether because you are so obsessed actually this plea of lack of jurisdiction so now of course you are registering section 9 you will register the best case is that the suit is dismissed will you not take that plea before the Bhubaneswar court High Court will decide that
oh my lord my humble submission my lord that another applications has already been filed before the family judge Kendrapada and annexer 2 notice has already been and he will appear before the judge family
Mr. Sahoo then if
he will appear in one case why he will not
correct
in two cases
the hardship
for that reason my lord for the interest of
after you complete the announcement then I will discuss with you because you are interjecting so much after you complete then you tell me then you carry on don't interject the court
humble submission my lord it is a fact that one case that is the Madras case has already been filed before the judge family court Kendrapada and it is too difficult and it is hardship for the parties
which party
two parties
which party is facing hardship before this court husband has come to court same parties
no my lord
now
it is coming
now would you listen please
yes
you have said so many times hardship to the parties now what is the difficulty 125 to Bhubaneswar
difficulty is
because the reason both matters will be heard by the Bhubaneswar court so you choosing a place for 125 actually you have not read 125 the territorial which provision provides 125 territorial jurisdiction that is not bound by CPC
no I have filed the application
a small question I have filed the application which provision provides territorial jurisdiction for filing 125
before the family judge Kendrapada
it is not family judge Kendrapada 125 is filed before the magistrate now after so which is the provision providing territorial jurisdiction
not 125 my lord I have annexer 2
अरे annexer केमती आसीओ सेटा गोटे provision पचला पर annexer कहउछन
144 I have filed
144 which is the provision upon 125 which is the provision that provides territorial jurisdiction section 19
section 9
section 9 read देखंतु आनचन भई आनचन
नाही
सेटा कहिबे ना ଏଠି ସେଇଠି ଆପଣଙ୍କ ପାଖରେ ଅଛି ତାଙ୍କୁ ଦିଅନ୍ତୁ ଉପରଟା ସିଏ ବି ଗୋଟେ କମ୍ପ୍ଲିଟଲି ରଙ୍ଗ ନୋସନ ତାକୁ ଆରେ ବହି ଦେଲେ କଣ ପେଶ କରୁଛନ୍ତି ବହିଟା ଆଣିନାହାନ୍ତି ଆପଣଙ୍କୁ ପ୍ରୋଭିଜନ ପଚରା ହେଉଛି which provision territorial jurisdiction 145 state go to 145
My lord.
you should have been prepared on that line state away the answer yes read 145 तो पाऊंगी ना
145 procedure.
read slowly then you will understand
I can.
what we have missed
Proceeding under section 144 may be taken against any person in any district where he is or where he or his wife resides or where he last resided with his wife or as the case may be
so which is relevant for you
for my mailer where
one for अरे कोड ना where फिर कोले 145 रो कोड आपन पर relevant 145 1
A B
B B
हाँ B
ଆପଣ କେନ୍ଦ୍ରାପଡ଼ା ଅଛନ୍ତି କେନ୍ଦ୍ରାପଡ଼ାରେ ଫାଇଲ କରିବେ
ଆଜ୍ଞା ବିଟା ମୁଁ
ସେଟା ଆପଣ 90 ସେଟା ଆପଣ ଆଣୁଛନ୍ତି 145 is different ଆପଣଙ୍କର 144 petition is not guided by section 19 or section 9 of CPC
no
it is guided by 145 B because the choice is given to the lady when I asked you that when the husband will seek that because I have filed section 9 since long there is a now 144(4) voluntary desertion is there I have sought for restitution of conjugal rights what type of decisions are also there so then both the cases should be tried together 125 आपण आगे फाइल करथिले ना सी आगे सेक्शन 9 फाइल करथिले today only just before you the young I mean very pretty young she was arguing the same ground 144(4) been rejected so now 145 आपण जोटा कहउचंती you are under a wrong notion that as if 125 the territorial jurisdiction is conferred by CPC or the family courts 19 or Hindu Marriage Act 19 it is not it is 145 145 and this court has in fact no jurisdiction to say that it will be guided by section 19 or so this plea 125 he cannot take a plea 144 rather in your case it is 144 144 the husband cannot take a plea because 145 itself says initiate where the because it's a case of maintenance illegitimate child mother father everyone is included it will be at the choice of the person claiming
that right my
correct so that is nothing to do with when you are reading section 19 section 19 all are or and you are saying don't read 3 and more 24 is still more interesting it says convenience of the parties High Court will say that convenience of one party so for that you have to section 24 you have to do some research on the case law that where High Court or Supreme Court has said that yes if the wife wants it will be there fair enough because the problem is that you 125 144 maybe you have not don't feel defeated it is good that you are arguing all the points 144 jurisdiction is 145 section 9 jurisdiction is section 19 of Hindu Marriage Act read with CPC again CPC there is this express provision section 9 but if I accept your argument 24 also nothing actually helps me to decide in your favor I am so much impressed with your argument but what I will cite because 125 if I cite 144 then I have to refer to 144 145 it is very clear the person who is seeking she has the choice even illegitimate child has the choice and this 24 the language is very clear it has to look to the convenience of the parties that I have to interpret convenience of the party the lady so you examine Mr. Sahoo And this point regarding 19 I have already rejected because I have not marked it to be reported. Section 19, the wife claiming before the revisional court that they were not staying in, but coincidental, I don't know, with the same case, Bengaluru.
Well, he has not put an application before the
The
Bangalore.
matter which I have considered, Mr. Hon'Ble argued, in fact, quite well actually.
My lord,
He said that 19 is a bar. In fact, he elevated to that level. So I have given that in view of 8, but definitely it will be open for you to before this court whether 19 has been satisfied or not. Trial court has to decide that. That I cannot say. Because if you want to register a suit, and it is
factual aspect.
Mr. Sahoo, you have developed the habit of listening. What is being told to you, it is not everything is against you. That is how you are struggling.
My lord,
Not a single sentence is I have been able to tell you which you have not interrupted me. I am saying something else, you are receiving something else. And 24, your terms are, it cannot be, because it is the convenience of the parties.
my lord, problem, my lord, is that date has already been fixed and someone has already been issued.
There you seek adjournment. You prepare yourself for.
I have filed an application, my lord, for, and that.
No, after I issue notice, then you are, because I can't direct interfere.
And a date has already fixed, my lord. I have annexed.
You can't avoid lawyer, mister.
Annexed to.
The lady cannot avoid a lawyer for engaging at Bhubaneswar. That strategy is a bad strategy. She has to engage a lawyer who has to take adjournment.
So, Bhubaneswar, I can have परिस्थिति.
Don't blame Bhubaneswar lawyers. You are appearing in so many cases. Bhubaneswar courts are also overburdened. So,
overburden है. मैं कौन किसी problem overburden 17/3/2026 के आगे date ଅଛି.
ଆପଣ ତା ପୂର୍ବରୁ ଆସିବ ନେକ୍ସଟ ୱିକରେ ଆପଣ ସେଇ ପଏଣ୍ଟରେ ଦିଅନ୍ତୁ ସାଇଟେସନ ଯେ 24 has to be read convenience of the party, particularly the lady. That's the problem that I cannot distort the statute. ଆପଣ ସେଠି appeal କରିକି କାହିଁକି when you are registering any suit, dismissal of the suit is in your favor. That's a point in your favor. Now since you are getting adjournment, that's a different thing. It is already time happened something. ଆପଣ ଡେଟ୍ କେବେ ଚାହୁଁଛନ୍ତି?
17/3/2026 ରେ ପୋଷ୍ଟିଂ ଅଛି.
List in the week commencing 9th. I'll pass the order after I come back.
ଆଜ୍ଞା.
9th week ରେ ଆସୁ ହେଲା. Yes.
Item 11, my lord, for next week.
जोड़ा का adjournment, both sides are there. Kindly please inform your other side. They are waiting at 4. They are standing up and saying that we do not know our matter has been adjourned. Update them a date. Both sides जो अछंती आपण convenient date कहले से कर देबे. It is your, I trust all of you. अच्छा, yes. Back and resuming this list.
On defect matter, again, my lord, I will come.
No need. Well, thanks for your time and patience. Though you are a little bit impatient in allowing the court to tell you something, but still, then you at least you have made an endeavor, participated. That sets example for others.
No, my lord.
Yes,
we have the face.
I mean, especially youngsters. Take your dates. Yes, please.
An order matter, my lord. It is effect, some defect is the notice.
Mr. Das, Mr. Ashwini Kumar Das, your matter?
Yeah.
You will be there after recess, after the division.
Item number 15. Item number 15. Sunil Kumar Patnaik. Defect. Order. Item number 15.
ଆପଣଙ୍କର ଯୋଉଡାକ ଡିଫେକ୍ଟ ପାଇଁ ରିମୁଭାଲ ଅଛି
7 days man.
ଆପଣ ଯାହା ଟାଇମ ନେବେ ସିଲେକ୍ଟ କରିଦେବେ
7 days.
ଠିକ ଅଛି ଆପଣ ଡେଟ୍ କେବେ ଗଲେ 15 ଟା କରନ୍ତୁ ଆଇ ପାସ୍ ଅର୍ଡର
7 days.
33
Item 18.
30 ଦିନରେ ଆସିବ ଅର୍ଡର ସବୁ ସେତେ ବାଟ ନେଇଗଲେଣି ମାନେ ଡେଟ୍ ଜାଗା ନାହିଁ ବୋଲି ଆଚ୍ଛା ଠିକ ଅଛି
Item 18, my lord.
ସିରିୟଲି ଯିବା ଆପଣଙ୍କର ଫ୍ରେଶ ମ୍ୟାଟର ପରେ ଫ୍ରେଶ କିଛି ଆଡଜର୍ନମେଣ୍ଟ ନାହିଁ
Item 8.
8.
18.
ହଁ ୟେସ୍
Orders matter, my lord.
ଆପଣଙ୍କର ଡିଫେକ୍ଟ ପାଇଁ କେତେ ଦିନ ଚାହୁଁଛନ୍ତି
Within 2 weeks.
ତାହେଲେ କେବେ 18 ଟା ଆଇଟମ 15 ରେ କିଏ ଆପିୟର କଲେ ମିଷ୍ଟର ସୁନୀଲ କୁମାର ପଟ୍ଟନାୟକ ମିଷ୍ଟର ଅନିରୁଦ୍ଧ ଦାସ
My lord.
ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି 30 ଦିନ 18 ଟା କେବେ ରଖିଲେ
My lord.
6/4
6/4 କହୁଛନ୍ତି ନା ଅଲିୟର ଚାହୁଁଛନ୍ତି
6/4.
ଠିକ ଅଛି
Obliged.
ୟେସ୍
Item 19.
19
15 days
limitation.
Sir, 15 seconds in limitation is limitation. To read Limitation Act, it does not distinguish between 15 seconds, 15 or 15 hours. But obviously, it's a matter of consideration. कौन छेड़ा चाहूँ कौन?
এটা নোটিস হওয়া দরকার
Sir, judicial order ମୁଁ କରୁଛି already I have skipped time. So ଆପଣ ଯଦି ରହିବେନି କାହାକୁ କହିଦେବେ ଆପଣ କୁଲିକ୍ କୁ କାହାକୁ କହିଦେବେ ଠିକ ଅଛି ମୁଁ ମେନସନ କିଛି ନଉନି ଆପଣ adjournment ଯୋଉଟା କରୁଛନ୍ତି ବୋଲି ସେଥିପାଇଁ ମୁଁ କହିଲି ମେନସନ କଲି yes. अच्छा तो that's it 21 लिखिकी दे रखी दियंतु I'll dictate out other side not necessary
No, but because it has become interruptus.
Okay.
Because the proceeding which actually it is to be transferred, it is about to dispose of.
Yes.
Due to pendency of the transfer petition, the learned judge said that no, I cannot pass any judgment unless and until that order of withdrawal is given.
No, actually that's a fact, Mr. Mahapatra. You have vast experience. You realize that this branch, RPFM, TRPC, is causing a huge backlog for the trial court, pendency in High Court. And as a matter of legal strategy also, as a legal administration, Supreme Court is insisting, High Court is insisting, the tribunal matter. But in one matter, 5 years, 6 years, stay and kept pending. Yes. Yes, please. Doster. Mr. Deepak Kumar Sahoo for the petitioner. The petitioner wife is before this court. Wife in the marriage is before this court challenging seeking transfer of CP number 729 of 2025 filed by the husband in the marriage under section 9 of the Hindu Marriage Act for restitution of conjugal rights pending before the learned judge family court, Bhubaneswar. The petitioner wife wants the matter to be transferred to the court of learned judge family court, Kendrapara. The learned counsel for the petitioner heard extensively. It is submitted that in view of section 19 of the Hindu Marriage Act, the court at Bhubaneswar does not have jurisdiction as the petitioner and the opposite party husband did not stay together at Bhubaneswar. The learned counsel for the petitioner was requested to go through the pleadings. Wherein at paragraph 2, it has been clearly stated, quote, after marriage, both the parties were residing at Bhubaneswar. Thereafter, some days they went to Bangalore, into bracket petitioner's workplace. Now, not now, in view of the above, this court has to go into the issue of the place of stay of the parties, which is now disputed. by the petitioner wife. In considered opinion of this court, the said aspect has to be considered by the learned court where the proceeding is pending, and if such a plea is raised. The learned counsel for the petitioners then relies on section 24 of the Code of Civil Procedure, which provides thus. Section 24 टा लिखिए. The Lord Counsel has adjournment to address this court regarding the issue as to whether this court has to only take note of the convenience of the wife in the marriage without there being any statutory mandate for the same. List in the week commencing? No. 10/2024. Yes, next. ठीक है.
Item 13.
This is a petition wherein both wife and husband, they filed a petition for mutual divorce. It was filed before the lower court. For no reasons it is being lingered. On the plea, the counsel go for conciliation. This is as far as
13B has been filed, you are saying.
13B, 13B1 and B2, both. And separation, we are staying separately since 11 years.
You are already into that.
I'm for a husband, my lord.
Yes.
There is no question of reunion, my lord, but the long trial court is delaying the matter with a plea of conciliation.
Even conciliation date fixed kale. Sedina mein jayegi dijon ja koira. Jete previous case la, all those cases have also been withdrawn. Tankar jinsa patra phera sarlani. Husband has prepared the draft.
Since it is a statutory mandate and recognized.
No, it's not a statutory mandate.
I mean, have you filed for confirmation of that?
13B2 कराएंगे देख चुके सब जगह annex है जी.
That Harbin ko.
Page 21 में अच्छी है सर. B2 रे दी.
Page 28.
21.
21.
आइए. 23.
Harbin ko. Amardeep versus Harbin.
आपने एक भी recent judgment भी ऐसी है. से draft भी थोड़ा cancel हो रहा है. एक delay लगी.
What I'm doing, that I'm asking for a report from the state court. Because I cannot access say 13B. 13B High Court cannot access it.
I know, नहीं तांगो टा statutory कला अमुक दिन सारी दिया बोले सेटा जानता.
नहीं सेटा वाला positive response आसीबो. He will be happy, both of you will be very happy. So that way, it is kind of a.
से draft तार सर जाओ बस नहीं बहुत हैरानी है. Unnecessary कहीं कैसे करते हैं सर. तापर last time sir, मतलब last time I personally told him, आया दी पार्टी जाकर राजी होंगे, यदि conciliation का था वो, conciliation ने हम दिया ना तो मुझे refuse कर दिया, तो conciliation failed.
ଆପଣ ଫାଷ୍ଟ ଅର୍ଡର କନସିଲେସନ କେବେ କରିଥିଲେ ଏନି ଆଇଡିଆ?
10 ବର୍ଷ ତଳେ ଗୋଟେ କେବେ ହେଇଥିଲା, ଦିଥର ହେଇଥିଲା.
They are staying separately since 2014.
ଯୋଉ ଏଇ ଯୋଉ 13B ରେ କନସିଲେସନ କେବେ ହେଇଥିଲା? କୋଉ ଅର୍ଡରରେ?
13B ର conciliation. 13B ତ ଏବେ ଖାଇଲା ନା.
ଆଚ୍ଛା ଆପଣ ତାହେଲେ ଆଚ୍ଛା then I have not understood correctly. So after filing of 13B, then that is not a wrong approach. Because this kindly look at the provision where it says that it has to be sent for conciliation. It doesn't make any exception actually.
ସେ ହରଦୀପ କୌର ଉପରେ ଆଜ୍ଞା ସେଇଟା କହିଲେ that is
Harbin Kaur has the advantage of Supreme Court.
ହଁ ନାଇଁ ଏଠି
we are directing. ଆପଣ ଯଦି କହିବେ then without waiting for conciliation Harbin Kaur direction ଦେଇଦେବା. Yes.
Man, there is no question of reunion.
ଓ ସେଇଟା ଆପଣ ତ 10 ଥର କହିଲେଣି. ଆପଣ ଯଦି question of there is question of union ଥାନ୍ତା ତାହେଲେ ଆପଣଙ୍କ କିଛି ଆର୍ଗୁମେଣ୍ଟର କିଛି ଭ୍ୟାଲ୍ୟୁ ଥାନ୍ତା. ସେଟା ତ
ଆପଣ କିଛି ନାହିଁ ପାରେ.
ସେଟା ତ So you agree that both of you agree that I'll direct condonation of that Harbin without waiting. Order ଗୁଡାକ କୋଉଠି ଅଛି? Division bench order, but that is no. I don't have that power. That is a power by the division bench, I think.
Which one? ସେଟା ଦେଖିଲେ ଆଜ୍ଞା ସେ ଡାଇରେକ୍ଟ ଅର୍ଡର ଦବାଟା ଫର ଡିଭୋର୍ସ.
ନାଇଁ ସେଟା ତ division bench ରେ ବି ନାହିଁ.
ହଁ division bench that is with the
but those Harbin Kaur orders I have passed the orders in sitting in division. That I am saying.
ଆଜ୍ଞା ନାଇଁ ହରବିନ କୌରରେ କଣ ହେଲା ଗୋଟେ ପ୍ରିନ୍ସିପଲ ଦେଇଦେଲା କି କଣ how long parties have been married, how long
Ashwini Kumar asked for the just kindly both of you take your seat. I think I'll dispose it off. But there is you are taking a risk. I am not very sure that whether I can direct the family court, because it's a division bench matter, to follow Harbin Kaur. Family court has to follow. But that power, to my understanding, is power of the division bench.
ଆମେ ଦି ଜଣ ଆମକୁ ଆଜ୍ଞା ଅବିକା କଣ ହେଇଛି ଚାହୁଁଛୁ କେମିତି ରହିବେ ଭେରି ଅନେଷ୍ଟଲି କହିଲେ ସେ ଝିଅ
that is there. So but that kind of order, but I mean I have passed to sitting in division. That I wanted to take your seat. Mr. Ashwini Kumar Das for the petitioner. Mr. Take the division. The petitioner wife is before this court.
Yes.
So wife is before this court. Challenging the order dated 04.02.2026 passed by the Honorable Judge Family Court /2 Bhubaneswar in CP number 1031/2025. You have filed caveat, Mr. Patnaik?
No, ma'am.
Okay. The CP was filed, the CP number 1031/2025 was filed under section invoking section 13 into bracket capital B into bracket English of the Hindu Marriage Act, seeking. You can't make the sentence out there, please. You file it in CP number 8 is a joint application. So in short, is a joint application by the husband and wife in the marriage. पर invoking कौन लिख लिया? Seeking divorce on mutual consent and dissolution of solemnized between the parties on 13.05.2013 at Bhubaneswar. To further the cause, the following factual aspects has been stated by both the parties in the said petition. There has been a disagreement and lack of understanding between the parties. They have remained separate from each other for more than 10 years. Several litigations have been initiated at the instance of both the parties against each other. Stop. Then that point, next point. ABCB rupees 15 lakhs has been agreed as permanent alimony to be accepted by the petitioner wife and for expenses and maintenance. For the expenses of the child born from the wedlock, who is now aged about 12 years. For a child right, child cannot waive his right.
Say withdraw person. Undertaking
जो child रे अपन लिखिले, any rights herself the child with regard to any tangible aspect of the petitioner. Child is the son. So that he cannot relinquish his rights. Anyway, he's a minor. I don't know what is the language used. That's all. The counsel for the petitioner was heard at length. Submit that both the parties to the litigation are looking forward to their respective individual lives separately, and prolonging the litigation would be against interest of both the parties. So at this stage, Mr. Patnaik, Mr. Achyutananda Patnaik, Learned Counsel, and Learned Counsel appears and submits that he has instructions to appear on behalf of the opposite party. He files Wakalatnama duly executed by the opposite party husband in the marriage. Wakalatnama shall be taken on record, scanned copy be updated. In view of appearance of Mr. Patnaik and Learned Counsel and associates, no further notice be issued to the opposite party. The matter is listed for fresh admission. The Learned Counsel, Mr. Patnaik, seeks leave for addressing the court, and he is granted leave to address the court. Stop. It is submitted by the Learned Counsel for the opposite party husband that the opposite party is completely in agreement with the prayer made in the present application. That application that the matter should be expedited and closed at the earliest. When Counsel Mr. Das appearing for the petitioner wife refers to 21. Refers to page 21 of the petition of the which is copy of. This is part of the copy of the IA number 61 of 2025. an application filed before the Family Court number -2 under section 151 of CPC, read with section 13 capital B into bracket English 2 of Hindu Marriage Act to waive the statutory period. Paragraph 3, 4, and 6 of the said application is three, 4, 5, 6, 7 कर दो 6, 7, 8 reproduce कर दो para. It is submitted by the learned counsel for the petitioner that despite filing the application, the learned judge family court has not exercised its discretion to waive the statutory period as directed as settled, not as settled as Amardeep Singh Supra. Both the learned counsel for the petition, the opposite party, seek this court interference for waiving of the statutory period. Statutory period provision. সেটা তো ওয়েব এজো যেটা ওয়েব হবে সেটা কোর্টে আছে আমরা ইনপুট ডেটাটা কোন পেজে যাচ্ছি পেজ
page 26.
इलेवन टू पर कुछ ऑर्डर ही नहीं
है
कौन लिखले as prescribed in 13 dash capital B into bracket English 2 of 6 months after the date of presentation of the petition. Para. Now, by exercising the power of this is a problem area. What power I can exercise? Perhaps I don't have 227 here. 227 is, I think, it's a division bench.
Yeah.
Tribunal matter is a division bench matter. Now, in view of the submissions made by both the learned counsel for the about a memo file करो Mr. Patnaik.
Well,
you file a memo that you agree for
waiver.
Okay. Language that Mr. Das can settle. Upon settle कर दियो. He will please say settle it. All right. For the parties to waive out the period, statutory period for granting decree of divorce, and in view of the law laid down by the Honorable Supreme Court in Amandeep Singh versus Harbin Kaur into bracket 2017 bracket closed 8 SCC 746. It is directed that the Learned Judge Family Court dash Roman 2 shall not detain itself awaiting completion of the statutory period as prescribed in section 13-B into bracket English 2. The court shall proceed expeditiously in the matter to decide the application under section 13 into bracket B in accordance with law and in the interest of justice and fair play. As well as not fair play, as well as in the interest of justice, as sought for by both the parties. With the aforesaid directions, the petition stands disposed of. The petition is allowed. The petition is allowed and disposed of. Mr. ये appear करें Mr. पटनायक की appear करें सेठी insert करो तो तौले लिखी दियो तो insert पर moving कर दो Mr. Patnaik, Learned Counsel, on behalf of appearing for the opposite party husband, files memo stating thus. Quote कर देले तापर लिखिए The memo is taken on record, scan copy be updated. इटा को अपन तौले टाइप कर दी था तो सेटा गुड relevant जगह रे insert कर दो Next year question ठीक है 14 Yes. Andy. What is question? The disposed of case appear collected upon recall.
For recall of the order.
So the Supreme Court decision is there. 97 or 90 decision. 97, yeah, 97. Good. खाली एमपी अर्जन करून ताले WPC number इत्ते the writ application was disposed of by order dated 26/9/2023. IA number 408 of 26 has been filed for recall of the said order. So, however, by a different set of counsel. Proper लिखो Saparakari non appears for the petitioner when the matter is called. List in the week commencing 13/4/26 Mr. Prem Kumar Mohanty लिखी, Prem Kumar Mohanty for the opposite party. आइए टा चलिए ऊपर बोधे रीड रहबो तळे आपनकर ऑर्डर इन पोर्शन रहउची एटा. Yes, next please. 15. Mr. Sunil Kumar Patnaik for the petitioner, opposite party blank. The learned counsel for the petitioner seeks further time to remove the defects as pointed by the staff report. Accordingly, for the time is granted, the matter shall be listed in the week commencing 13/3/2023. Upon upon removal of the defects, registry shall do the needful. दरकार नहीं से तो डायरेक्शन है ना से लास्ट टाइम काटी दियो प्लीज. नेक्स्ट प्लीज. 16 के मेंशन कले 16 का none appears for the petitioner when the matter is called. The matter is kept pending since 2021. Defect as per the stamp report. Date kete on देखुनांदी. Defect as per stamp report dated 13/6/2021 has not been complied with. Apparently, stop कर लिखिए apparently comma. सेटा से फाइले लगेबे 13. So urgent certified call urgent certified copy as per rules for the सेटा apparently comma the petition does not contain the certified copy of the impugned judgment. Stop. The matter will be listed on कितने देबे orders we commencing 30/3/2026 indicating that the matter shall be disposed of. Para registry shall intimate the next date of listing of the matter to the learned counsel for the petitioner. Stop. The defects as pointed by the SR as a last chance may be removed within 6 तारीख ना by 23/3/2026 25 कर दियो 25/3/2026 listing date last को रह जाता ना. Yes, next. 17. Mr. Aniruddha Das for the petitioner, opposite party blank. Again, sorry, 17. 17. He mentioned 17 रे भी आपनकर 16 रे जा ऑर्डर 17 से ऑर्डर कर दियो. None appears for the petitioner when the matter is called. 16 रे भी सेटा 25 जाए टाइम दिया है 30 रे आसीबो से जोटा पूरा लिखि देबे सेटा जस्ट रेप्लिकेट द ऑर्डर. 91 कतले हो कते 91 टा देखि दो defective certified copy not furnished. So 912 जहाँ खाली 91 और 2 लिखी दे डिटेल तो पढ़ी होनी. ठीक कॉल करन तू 18. So Aniruddha Das for the petitioner, opposite party blank. The learned counsel for the petitioner seeks further time for removal of defects as pointed by the SR. Stop. Accordingly, the matter shall be listed in commencing 6/4/2023. Defects as pointed by the SRs be removed in the meantime. Yes.
Right.
Yes, please.
15 days delay content and issue notice to opposite.
ଆପଣଙ୍କ ନାଁ ପରିଡ଼ା?
Urmila Mahanti.
ଆପଣ ନା ଉର୍ମିଳା ମହାନ୍ତି ନୁହଁ ମୋ?
Warrior.
SR ପରିଡ଼ା?
Yes, Miller.
Mr. SR ପରିଡ଼ା. Term 19. Mr. SR Polda for the petitioner. Yes, what is the case, sir? Why the since 2022 it is pending?
Only 15 days delayed.
Defect called remove any?
Yes, Miller, defect.
Defect removed. What is the order reviewed?
Not challenging the judgment passed by.
Correct, sir. What is the judgment? What is the order in portion of the judgment?
Enhancing
enhancement.
Yes.
Good. Which provision? Take your seat. I'll dictate those. The petitioner wife, you sit down, you take your seat. The petitioner wife is before this court seeking enhancement of the maintenance granted by the Lord Judge Family Court in Criminal Proceeding number 2018. Lord Judge Family Court Kotak. By judgment dated 808.03.2022. Had learned counsel for the petitioner issue notice in the IA as well as the application has been filed. Can I click on it? नहीं बुकमार्क कहीं खोलूं एसआर खोलूं तो नाम रिपोर्ट स्क्रॉल डाउन तो किए मूवी करि परिबी कोन छै मगर ऑफिस नोट रे नथिबो सेटा पिटिशन ने एसआर थाए पिटिशन भी खोलुनी अरे आपण देखु नांती की अरे स्टाफ रिपोर्ट रे डिलेटा देखि नांती ओरे साउडी फिजिकल कॉपीटा देखा आपण यूज करना छी मु जेति करछि पेपरलेस है और देखा कितने दिन डिले
15 days.
तो मु कोडा खोलछि त एफएम पे 151 माने मु जो पेज आपण से पेज सर आउडा अरे सेटा रे 1353 आपण 15 पूछछन्ती मु मैजिक करछन से खोलु नथिला मु त खोली पर नथिला एक्चुअली मु भी 15 डाकियो जाउथि 1353 आपण 3 टा मिस करी गेले दीटी जाको 1353 रो दीटा 3 काटि देबे 15 हे गला एटा केमति हो
The state
है कोन इंस्ट्रक्शन नियम तो एथरे कोन 1353 दिन डिले कोन एक्सप्लेन करिवे As per the staff report, the application has been filed after a delay of 1353 days. ଦେଖିଲେ ଆପଣ ଯେତେବେଳେ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଦେଖିଦେବେ, that is the best way, so that you are confident what you are arguing. 1353 days. Issue note on the question in the IE petition करंतनी. Requisites for issuance of notice by a speed post with registration and proof of delivery be filed within 5 working days.
Yes, my lord.
Within 5 working days. After SR, liberty to mention. It is further directed that the wife shall continue to receive the amount of monthly maintenance granted by the judgment dated 8/3/22 as the Learned Judge Family Court in CP number 111 of 2018 without prejudice to her rights and contentions in the present application. Yes. Next. Shirot Kumar Raut for the petitioner. Yes, please.
Please, Your Lordship. Here the petitioner challenge the order dated 18/4/2022, my lord.
Yes.
Passed by the Learned Judge Family Court Bhadrak, enhancing the amount from 5,000 to 10,000, my lord.
125.3.
No, my lord, 127. Sure.
127.
My lord.
Enhancement 127.
My lord.
Order.
But the wife is a government servant, government teacher, my lord. She is getting 40,000 per month, my lord. My lord, the doctor.
Where you have taken that stand that she is a government servant and getting, and what is the observation of the court?
Yes.
Because scope of RPFM is very well defined.
My lord.
Because this court cannot interfere if it thinks that another conclusion can be arrived. Now you have to show that you have taken a plea. What is the consideration by the learned trial court regarding that her getting employed, and because yesterday there was a matter, the wife is employed as a ARI. The petitioner, she got carried away. She says that the court has been gained over by the, but that particular evidence has been taken note of. Her salary certificate has been taken note of, and she has been awarded 4,000 rupees. So she might have been awarded 20,000 rupees. So that sort of a mistake, at least this court should not make, that without realizing what has happened. Yes, well, in your case, did you take that stand? This particular petitioner has taken that stand by filing.
Yes, taken that, my lord. Let's go next week, my lord.
Otherwise, there is no point in keeping the matter pending, Mr. Rao. Because it depends on if a government servant, say, is earning, say, I mean, it can go up to a government servant, the salary can go up to 1.5 lakhs. 1.3, 1. That up to certain kind of service. But she is married to a person who is a millionaire. Now the law has developed that very clear.
But under section 1,
capacity to earn of the wife, education is not a criteria for denying her maintenance. That's the problem.
Right.
I mean, that's the legal. It's not a problem. Problem for the husband, but the legal. The issue is now finally answered by the Supreme Court.
But
it cannot be left to my personal predilection. Maybe that she should not get because she's working and she's capable of earning. But the law has now stands very clearly stated in Rajesh versus Ney and subsequent decisions.
But under section 125, she is not entitled when she is unable to maintain herself.
No. 125 has been very clearly discussed. Proof of neglect is enough. Upon jodi daunanti, Mr. Raut is not giving money to Mrs. Raut. That is enough. Whether Mrs. Raut is, please don't take it that way, because it is easier for me to tell you. Mrs. Raut doesn't have to prove that whether sufficient is enough that she is not being given. That is. Or you can say Mr. X, Mrs. X. Yes, କେବେ ଆସିଲା ହବ? Mr. Khirot Kumar Raut for the petitioner. ଆପଣ କେଉଟାକୁ KI ଆପଣ କରିଛନ୍ତି କଣ ନ୍ୟୁମେରିକାଲ ନା ଏଟା ଭୁଲ ହେଇଯାଇଛି? Your name is KU na?
KSHI.
But Kumar has become Kimar.
Sorry, wrongly.
KK Raut for the petitioner. High Learned Counsel for the petitioner. The matter is adjourned for that.
Someone is
hearing this week commencing.
Someone is appealing for opposite party number 1, Mr. H.K. Naik for
H.K. Naik. Are you?
No.
One is it?
He is appearing from Bhadrak Miller.
None for the opposite party person. The matter is adjourned to be taken up to be listed in the week commencing. It is thin. Chabis. Yes, next. Connected Mr. Raut was present, I think. Connected method. Have you marked Mr. Raut? I mean, Mr. Rajendra and Raut.
Yes.
So who is it?
That case has been dismissed. I have filed an application for recall of that order.
Acha. When RPFM 15 of 2017, in view of the order passed in the connected RPFM 213/2022, the matter shall be listed in the week commencing 30/2026. Yes, next. Item 21. So Rudaranda Matra for the petitioner. Your name, sir?
My name is Somberanjan Swai. I am appearing on behalf of Rakesh Kumar Das, opposite party.
Mr. Somberanjan Swai on behalf of Rakesh Kumar Das for the opposite party. The petitioner wife in the marriage had filed the application before this court seeking a transfer of MAT number 68 of 2024 from the Court of Learned Judge Family Court Bargar to the Court of Learned Senior Civil Judge Kamakhya Nagar. Stop. The said MAT case number 68 of 2024 was filed by the husband in the marriage. You take your seat. They are withdrawing.
Yes.
Yes. So I'll take some time to dictate the order. Under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Stuff. The matter is pending since 2024. The matter was presented before this court. Date pit kai padu. On 5/3. The matter is pending since 2024. Notices were issued by order dated 21/11/2024 Para. Today, when the matter is called, memo of date is filed by the learned counsel for the petitioner, which states thus. Copy of the memo shall be taken on record, scanned copy be updated. The petition accordingly starts disposed of. Copy of this order shall be forwarded to the learned judge, family court, so and so, to be kept in the records of MAT case number 68 of 2024. Learned judge, family court, Burger, to be kept in the records of. Yes. Next.
23.
Yes, please.
May I please your lordship? My lord, by virtue of order dated 16/10/25, issue notice to opposite parties, but opposite parties left that address left.
You
S.K. Rautray.
Yes, you have power. Mr. S.K. Rautray. Your full name?
Saroj Kumar Rautray.
Saroj Kumar Rautray for the petitioner. So can you discover present correct address? Any idea?
One more address is there. I will send.
No, but before take steps, but be sure that because this process of sending again and it takes a lot of time.
That faster
So I'm
address.
granting you more time. Try to ascertain. Talk to your client.
My lord.
Get some information, like local information, who can inform you. That is not in the sense your client should inform you that yes, that's a possibility of. The notice says item. SK Rautray लिख लेते. Notices were issued pursuant to the order dated 16/12/2025.
16/10.
16/10.
My lord.
ଏଇଟା ମିଳୁନି. ମୋର 16/12 ଦେଖୁଛି. ଦେଖନ୍ତୁ ସେଇଥିରେ ଦେଖୁନାହାନ୍ତି. ଛୋଟଟାରେ ମୋବାଇଲ କଣ ଏଟା ତ ଆପଣ ସାମ୍ନାରେ ଥୁଆ ହେଇଛି ଆପଣଙ୍କ ପାଇଁ ଥୁଆ ହେଇଛି.
My lord.
Order number 1.
16/12.
ଠିକ ଅଛି ତ? Issued by order dated 16/12/2025 by the court bench. Stuff. Office note put up by the registry indicates that the notice has been returned answered with postal endorsement. देखिए लिखते हैं within court. Para. It is submitted by the learned counsel for the petition. The petitioner has obtained. The petitioner shall obtain present by address of the opposite party to take notice afresh, and some more time may be granted. Accordingly, further 3 weeks time granted to obtain present and file requisites for issuance of notice by speed post with registration and proof of delivery. Upon filing para, registry shall do well to issue notice to the opposite party fixing returnable date. Unutilized copies of requisites shall be utilized. Yes, next.
God bless.
Yes, please.
24.
The Jenna is not there.
I had the.
You are appearing in.
No, I had the instruction, my lord, to appear for the respondent number 2.
Okay.
For whom the land has been acquired. And in fact, they also seek leave to prefer the appeal.
Because they are not parties.
Yes, my lord.
One thing, Lord, the leave here, the wife has come, husband is dead, and the other legal heirs mentioned whether because the wife is of 70 years.
That is correct, but the problem is that you must understand that the lawyer is also struggling.
Yes.
He doesn't have instruction. So he is taking that risk. So Jenna, he is a seasoned counsel.
Yes, sir.
Because he cannot never, this 53, I mean, another, I don't know how many it will happen.
Now, once he applies for leave to appeal, he must say that there is no other legal heirs because the original father-in-law is the original person who contested, the Kedu Behera. And now Panchanana Behera, one of the...
Actually, I have recorded that. Kindly mark order number 2, paragraph 2.
Yes, yes, Lord.
IA number so-and-so has been filed for leave to appeal, chapter so-and-so. It is submitted that though the present appellant was not a party before the referral court, still he is vitally interested in the matter, being the legal heir of one of the original land users. So in fact, he doesn't dispute that there are so many land users, he is one of them.
Not necessarily that all of them should come in appeal.
Correct.
And but the thing is that I just wanted, my lord, if my learned friend would have served a copy.
He usually is present either.
Definitely. He's
normally, even if
probably some difficulty has not appeared.
be made formal parties.
That's
yes.
IA लिखूं तो 218.
I will inform my lord.
Yes, IA 218 of 2025. IA 217 of 2025. चला editor लिखिए along with LAA 76 of 2025. The learned counsel for the petitioner is not present. Stop. Mr. SK Das, senior advocate, along with Mr. P.K. Das.
P. Das.
Mr. P. Das. Mr. P. Das, learned counsel, submits that he has instructions to appear on behalf of the respondent number 2 in the LAA. As well as, not as well as, accordingly, in both the IAs, leave to appeal and condonation of delay. Duly executed wakalatnama. Mr. Das filed wakalat?
No, an instruction on file.
It is submitted that how much time?
1 week time. Within 1.
To execute duly executed wakalatnama shall be filed within 7 working days. Mr. Jena is here. Yes, Mr. Jena.
Yes, my lord.
So Mr. Das has instruction to appear for R2.
Yes, my lord. He was
अब ठीक है ये पढ़ो पढ़े सर ऐसे देखी पढ़ना
well, I'm he was appearing in the lower court also. That's
so
why
you come to your right actually. Now you can see him. Yes.
Let him appear. I don't know.
Yes. But you can hear Mr. Sahoo again because you are not present. The Lord is something which has some relevance, of course. So this will be urgent because they will file wakalatnama within 7 working days.
Yes, sir.
But just you hear what Mr. Sahoo is saying.
30 seconds. Restaurant
within 7 days, and it is submitted by Mr. Das, learned counsel, is that he shall also file the appearance memo of the senior advocate for Act 2. Upon filing of the wakalatnama as well as the appearance memo, the same shall be taken on record, scanned copy be updated. Name of Mr. Name of the learned senior advocate along with the learned instructing counsel shall be indicated in the cause list as well as the case brief. Yes, Mr. Sahoo.
My lord.
Since he has come, you just reiterate yourself.
Here the leave to appeal is filed and the application appellant Dulon Behera, but she is claiming to be widow of Panchanana Behera. And there is no mention that there is no other legal heir. She is sole survivor after death of her husband. So other legal heirs must be there. The son and daughters might be there. They have not been made party. Either of appellant or respondent.
Mr. Jena, you obtained that instruction.
Yes, ma'am.
Because in absence of after demise of a particular litigant, I mean, maybe the claimant or the land housee, all legal heirs have to be there.
Yes, ma'am. That's
At least for this branch.
yes.
Yes.
For this particular branch, Dulana Behera, along with all.
Yeah.
That, I mean, that is the, I think that's the submission that is being made.
Yes.
List in the week commencing? 6/4/2026.
Instruction and I will.
One more thing, Mr. Jena, please have copy.
Yes,
Or Mr. P. Das.
Yes, please.
Copy of the appeal memo. I and papers shall be served on Mr. P. Das, learned instructing counsel, appearing for R2 within 7 working days.
Yes, madam.
Within 7 working days.
Yes, my lord, when started dictating, recorded the absence of the counsel for the
So should I correct it? That is a standing instruction to my staff also.
Yes, my lord.
And there is another problem also. Suppose they will write somebody else's name.
Yes, ma'am.
That is another problem. So, first line tag Mr. Kishore Kumar Jena for the. Thank you, Kishore Kumar Jena for the petition.
35.
Yes, Mr. Swine.
I think permitted to withdraw. Lord.
You take your seat. I'll dictate those. I'll take some time. Basantu. Mr. Bitas Kumar Swine for the petition. The matter was heard at length. The matter was heard at length on 19/1/2026, and the following order was passed. Order number 1 karte hain. Stop. Today the matter is taken up. Para the matter is taken up. Memo of date is filed by the learned counsel for the petitioner, which states thus. Memo shall be taken on record, scanned copy be updated. The application stands disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Jagat Singhpur, to be kept in the records of CRL.P. number 136 of 023 2023. 136 of 2023. Petitioner, none. Opposite party, Mr. P.K. Sahoo, AC.
I have got one instruction that the letter has been addressed to the director by the DO, who is one of the opposite party, that arrears shall, for the purpose of arrears, they have requested for sanction of this amount of around 98 lakhs somewhat.
I think this is that case where after government has sanctioned, he has not received.
No, this is.
If you look at that order number 1.
Order that. They
After
were
dismissal of SLP, the district DO has issued office order so and so, fixing pay of the petitioner along with subsequent implement.
Pay fixation has been done.
After the order dated has been passed. So anyway, so maybe he's
after this
coming back. That is it.
I know. Further instruction.
4 weeks.
4 weeks time further instruction. Yes. So
it is submitted by the learned additional standing counsel for appearing for the opposite party that steps have been taken after the order by this court in the present contempt application dated 12/2/2026 as per his
dated 27/2/26.
27/2/2026 from the DO.
From the DO addressed to the director
From the district education officer.
addressed to the director.
Balesur.
Okay, Balesur.
Balesur addressed to the
Director of Secondary
Director
Education
of Secondary Education.
for allotment of fund.
Stop. List in the week commencing 4/4/2026.
27.
Petitioner none, opposite party none. List in the week matter is listed for admission hearing. List in the week commencing 4/4/2026. Mr. Samir Kumar Das for the petitioner. Mr. P.K. Sahoo, additional standing counsel for the opposite party. The matter being in the list is mentioned by the Lord Counsel for the petitioner. It is submitted that the matter is pending since 2023 and relates to the financial dues of the petitioner. Stop.
One line.
Submitted that the yes.
The connected case we have already filed count by the same person.
Yes.
I will file here also.
Yes.
That line already.
To be paid by the state, but to be use of the petitioner to be paid by the opposite party state. And counter has not been filed. Stop. In response, paragraph the Lord additional standing counsel submits that he has already received instructions and Parave's comments. Counter and some further time may be granted for filing of the counter affidavit. Having heard Lord Counsel for the parties, it is directed that counter affidavit on behalf of the opposite parties upon serving copy thereof on the Lord Counsel for the petitioner. The petitioner shall have liberty to file file rejoinder in response to the list in the week commencing 13/4/2026. जो एस रॉय कौन से अपियर करना आगे स्वप्निल रॉय नहीं क्या अपियर कुछ वकालत नामा खार अच्छे देखो
It must be traced Loklatna by Mr. S. Rai.
S. Rai is already his associate actually. So Phil Rai is associate of
yes.
I mean Justice Sarpati as their lots of us. But वकालत नामा तो दास करो नहीं.
Last case will cover the second case also because that is the absolute of the next.
Second लिखी दियो तो Mr. S. Roy for the petitioner. सेटा तो नाहन दिसे ठीक अछि. The matter is listed along with the connected WPC number 4300 of 2023. By the Lord Additional Standing Counsel, the counter has already been filed. Stop in view of the order passed in the connected petition, the matter shall be listed along with the said petition in the week commencing 4/4/2026. Yes.
29.
May I please?
Mr. Jitendra Kumar Digal for the petitioner. Not filed.
May I please?
Complaints affidavit so cause not filed.
Your Lordship, see the last order, your Lordship, some direction is there. Because writ appeal is filed, here the conviction is there and that's it, some queries. Conviction has been stayed or not, and whether it's still incumbent until now.
Para 3-4, you have to answer, Mr. Digal.
My lord.
Para, kindly look at order dated 15/1/2026. You can use this paperless also. Why you are using small mobile phone? It will be difficult to read. This is only kept only for you to read. Kindly help it. So bookmark ta kholi ki kar diyon. 15/1. Order number 8, 15 January 20. ସେଥିରେ କ'ଣ ବୁକମାର୍କ ନାହିଁ ବୁକମାର୍କ ସେଥିରେ ରହୁନି ସେମ୍ ତ yes so state just on that order it will open just to
I have verified the best court decision, my lord. Even the
tell the name, sir.
One is, my lord, State of Jharkhand versus Jitendra Kumar Samantray Srivastav, sorry,
who payment of pension.
Yes, ma'am. 14/8/2000.
Jitendra Srivastav is not on payment of pension. Read it.
Employment pension withholding the pension gratuity in absence of
gratuity.
Pension and gratuity.
No, you are not reading, sir. You read the last portion of Jitendra Kumar. That is a decision directly against you. Last but penultimate paragraph you read.
15. Last paragraph, my lord.
It is a decision directly against you. Give me, I'll tell you. Anyway, this is a contempt. So, but since it is academic, so I am just trying to encourage you. Yeah.
And another decision, my
lord. Dr. Sarantu ago. It is upon quick, quick no. But though I remember the paragraphs and the citation, but when you are ଏଟା କଣ ପଢିଲେ ଏଟା କୋଉଠୁ ଆଣିଲେ
ସର୍ଚ୍ଚ କରିଥିଲି
ଏଟା ଆପଣ ଜିତେନ୍ଦ୍ର ଶ୍ରୀବାସ୍ତବ ଏଟା କୋଉଥିରେ ଆପ୍ଲିକେବଲ ହବ କଣ ଟିକେ ଅର୍ଡର ପଢିଲେ paragraph 3 please don't feel diffident what you are doing the right thing ପଢନ୍ତୁ
it is submitted by the Lord see that the petitioner in the present application was convicted by the judgment of the appropriate court in a criminal proceeding. Therefore, in view of the specific provision in Rule 6 and 7 of the Odisha Civil Service Pension Rule, the provisional pension received by the petitioner was stopped, and the state has moved in appeal challenging the order passed by the Lord Signatory directing payment of provisional pension. The referred government employee who has been convicted on offense by the competent court.
So now the problem is that Jitendra Srivastava is not a case of conviction, it is a departmental proceeding. And what the Supreme Court has said about part 10 upare. Then para 10 ଦେଖନ୍ତୁ ଏଇଥିରେ para ଏଇଟା ଦେଖନ୍ତୁ ଅଛି ତାର କପି ଅଛି 1 2 3 4 जो ଲେଖା ହେଇଛି ପଢନ୍ତୁ
there is also provision of Rule 43B which provide that one shall not be instituted one shall not be instituted save with the sanction of the state government, shall be in respect of the event which took place not more than 4 years before the institution of such proceedings, shall be conducted by such authority and at such place as the state government may direct and in accordance with the procedure applicable to proceeding on which an order dismissal from service may be made. Judicial proceeding, if not instituted with the government servant was on duty either before retirement or during re-employment, shall have been instated in the accordance with the subclause 2 of clause A.
Here is a case where you have been convicted. So Jitendra Kumar Srivastava cannot, rather 43B of Bihar Service says that government has power to withhold when you are convicted in a judicial proceeding, because government cannot exonerate you. They don't have a choice. And so rule 6 and 7, then a person who is not convicted is to get pension. Then conviction in a criminal case, have you marked the pension rules?
6-7.
Another provision that entails forfeiture of past service. Jitendra Srivastava says in absence of any rule you cannot detain. So that is against directly point. The rule is very specific. 6 is there, 7 is there. Forfeiture of past service. The other decision?
Other decision, Diokindan versus the state
Diokindan process versus state of Bihar. Which paragraph? First of all, whether it is a case of conviction in a criminal case or it is a departmental proceeding.
Proceeding.
That's the problem. You have to check out this question, whether after conviction, you have received any pension or you did not receive any pension.
The continuous pension, my lord, thereafter, after conviction, the pension was stopped.
So that you have to challenge.
Yes, ma'am.
So where is the discussion, where is the determination by the court that here is a case, after conviction in a criminal case, you continue to receive pension.
This order, my lord. In writ petition, my lord, 28968, my lord, finally see.
So you read this. It is not for me, because what I find,
yes,
whatever you are telling, holding the paper, I remember somehow.
My lord.
It may be a coincidence, but I saw which part the court has discussed that the after conviction.
My lord.
Which has been quoted of pension rules?
No, my lord, there is no.
That's the problem, Mr. You see, it is so easy for me if I have a precedence where the coordinate bench had discussed 6, 7, and I think rule.
I'm reading, my lord, this order.
Which provision, sir, the court has relied on?
Only relevant para, my lord, I am reading.
अरे relevant para no pension rules रो provision टारे court rely करी देचंती अपन को pension चला जो पढ़ुचंती.
ଏଇଟା ଗୋଟେ ପଢିଦେବି
उन तो provision निजे कोई बंधन करे ସେଥିରେ ହାଇକୋର୍ଟ କୋଉଟା ରିଲାଇ କରୁଛନ୍ତି କୋଉ ପ୍ରୋଭିଜନରେ ପେନସନ ଦବା ପାଇଁ
ଏଠି କରିନାହାନ୍ତି
so then how can I do? I have a difficulty as a high court judge. I have to refer to pension rules.
Writ petition.
The problem is that doesn't create a precedence. Otherwise, it becomes so easy. I'll simply rely on that decisions. Or maybe I have made a mistake. I have passed the order, same order, without referring to any law or any provision. When law stares at you, the pension is not paid from my personal. I am not giving you pension. It's public money. Whatever tax you are paying or others are sitting here are paying, including everyone. So it has, the pension is, though it is not a bounty, but it is governed by rule. If somebody is convicted of any crime, then what would be the consequence? Whether he will get pension, it is a rule is there. I like you very much, impressed with your submission, but still have to refer to, so you refer to those rule. Where Rule 6(7) have been interpreted by the court. And you will find several Supreme Court decisions on this point. Several Supreme Court decisions that Supreme Court has fought upon this, that High Court, without following any law, referring to any law or rule, granting monetary benefit, and that to pension, when it is governed by pension rules. He was dismissed from service. Conviction?
No, man. After retirement,
He has been convicted.
Yes.
Okay. Cite some decision where 3 and 4 where this has been, I have already passed order. So you have to cite those decisions of Supreme Court, which comes to your aid. If I cite, then nothing comes to your aid. Jitendra Kumar Srivastava, Devkinandan Prasad, both are not that point that after conviction, pension is to be given. Jitendra Kumar Srivastava says that when there is no rule, you cannot retain. In fact, Jitendra Kumar Srivastava is not also on pension, it is on gratuity.
Both are pension and gratuity.
No, you have not read. Just find that line where Jitendra Kumar Srivastava, the pension was stopped. You have not read the facts.
Devakinandan.
Devakinandan, kindly read which paragraph it says. Conviction, after conviction.
After conviction.
Then why you are citing? This is the problem. This is one of the reasons of the tribunal getting entangled in this. The Odisha Administrative Tribunal has passed hundreds of orders. After pendency of criminal case, following decision of the Supreme Court where disciplinary proceeding was involved. This mistake can be done by me also. But should I? While pass, because you have to tell the court correct, factually correct. The decision cited is regarding pendency of a disciplinary proceeding. Tribunal passes order, the pendency of criminal case. Read 51. Leave this habit of not carrying the book. Pension that you what to do? Are you here? Understood? So Puna gets so ଭଲ. What are you Puna? Just read it aloud. Rule 51.
They bring a person from the receiving gratuity.
ଆପଣ ଯୋଉ ଆସ୍ତେ ପଢୁଛନ୍ତି କୋର୍ଟରୁ ଆସ୍ତେ ପଢିଲେ କେମିତି ହବ?
If a person who in the event of death, government servant while in service is eligible to receive gratuity under Rule 50 is charged with the offense of
murdering the government servant for habilitating the commission of such an offence, his claim to receive his share of gratuity shall remain suspended till the conclusion of the criminal proceedings instituted against him. If
51 ଟା ପଢୁଛନ୍ତି ଆପଣ?
ଆଜ୍ଞା
yes, ତାପରେ
2. If on the conclusion of the criminal proceedings referred to the sub-rule 1, the pension concerned is convicted of murder of the debiting in the murder of the government servant, he shall not be paid his share of gratuity, which shall be payable to other eligible member of the family, if any, equal.
So even there is addition in pension rule for non-payment of gratuity. Jitendra says that 43B does not, there is no provision that to stop payment of, so that's it, that is how I told you that if the specific rule is there, Jitendra doesn't help you, that Jitendra is against you. And Devkinandan Prasad, you have already realized is a departmental proceeding. Pendency of departmental proceeding, Supreme Court decision is there, apart from Devkinandan Prasad, the other decisions are there. So the Learned Counsel for the
One more thing, writ appeal is pending, and here notice has been issued. He is aware of.
Let us see what is happening, because this is contempt regarding the. I am not sitting in writ appeal.
There is
that
no.
to Mr. Digal also, that I am not adjudicating that it what is a discussion.
Filed our so-called two affidavits there.
There is no stay order. In
Correct, sir, but I can't look at close my eyes. A convicted person will be granted pension. I have to be satisfied myself to enforce. My challenge is that I have to enforce it.
Man.
You must understand.
There is verify matter.
What was told to you was told after a lot of verification of years of research. That is how when you say a decision, I remember that. I will not be swayed by this kind of submission that Devkinandan Prasad, Srivastava, Jitendra Narayan Srivastava, all these things, because those decisions have been well discussed by this court. It's not that first time you are discussing this. This court has already discussed. Only clear? The Learned Counsel for the Learned Counsel for the petitioner was further heard at length. In response to order dated 15/1/2026, paragraph 3 and 4, should I record? There's no point in recording that because it is a contempt. He seeks further time to go through the provisions of law, Odisha pension rules, as well as find out if any decisions rendered by the Supreme Court where the person, after being convicted by a competent court, is to be granted a provisional pension despite the specific provision contained in the OCS pension rules by this court. Yes. Already paucity of time since perspective, so how can I go jaye gale apan? Then now mention which it 30. Other state में क्या अच्छी 30 अपन अच्छे
नहीं सर 33 पे
तब पोस्टिंग कर दियो तो सीधा कोई ऑब्जेक्ट को ना देना एडजर्नमेंट पे अपन तारीख पे तारीख दे चलो यस नेक्स्ट 31 नहीं 31 अब कॉल करो तुम खाली पे मेंशन नहीं कर तो yes Mr. Das, you are saying
I'm in 33
yes
I have so another appeal RPFM I'm sorry RPFM that should have been tagged earlier it was mentioned by my associate.
You give a memo. It's between same parties you are saying.
Yes, already given RPFM 23 of 26.
এটা আউথরে গোটে কাগজরে দেই দিয়ন্তু।
I can, just now.
But I am not passing any order since I am already beyond time. So
I'm conscious.
So rest of the matter should be listed. Take dates. Whoever is present want a particular date, it will be listed. 35 টা কোন হলো? Adjournment. Yes.
35, 39 হচ্ছে
39 টা भी
adjournment.
Yes. But 39 টা actually order ডকা হয়নি। এটা ডকা হয়েছে? না। Adjourn ঠিক আছে। Counter panel.